Good morning. The Committee on Homeland Security, Justice, and Public Safety hearing of April 3rd, 2025 is hereby called to order. Good morning, colleagues, staff, testifiers, and viewing audience. This committee's first official hearing. However, in late March, the committee held a community engagement session to hear from the community the concerns, needs, and ideas they may have for the work that this committee will be doing in the 36th legislature. I want to thank all that participated and engaged during this session. Madam Clerk, can I have a roll call, please?
Senator Angel Bulkes Jr.
Present.
Senator Bulkes, absent.
Present.
He's present.
Okay. Senator Bulkes, present. Senator Dwayne M. DeGraff.
Here.
Senator DeGraff, present. Senator Ray Fonseca. Senator Fonseca, absent. Senator Kenneth L. Gittens.
Present.
Senator Gittens, present. Senator Franklin D. Johnson. Senator Johnson, present. Senator Avery L. Lewis. Senator Lewis, present. Senator Clifford A. Joseph.
Present.
Senator Joseph, present. Senator Joseph. Mr. Chair, you have 6 present, 1 absent.
Thank you. We have established a quorum and will proceed. Madam Clerk, is there any correspondence to be read into the record?
There's no correspondence to be read into the record.
Madam Clerk, please read today's agenda into the record.
The 36th Legislature's Committee on Homeland Security, Justice, and Public Safety will meet on Thursday, April 3rd, 2025 at 10 a.m. in the Fritz E. Lowette's Conference Room on St. Croix, U.S. Virgin Islands. Block 1, 10 a.m. to 11 a.m. Bill number 36-0036, an act repealing and reenacting Title 20, Virgin Islands Code, Part 2, Chapter 43, Section 512, increasing penalties for traffic violations, establishing a Virgin Islands Police Department impound lot, and for other related purposes. Sponsored by Senator Kenneth L. Gittens. Invited testifiers, Honorable Mario M. Brooks, Commissioner, VI Police Department. Honorable Gordon Ray, Esquire, VI Attorney General, VI Department of Justice. Block 2, 11:10 a.m. to 12:10 p.m. Bill number 36-0024, an act amending Title 14, Virgin Islands Code, Chapter 85, by adding Section 1710, declaring a person incapable of consent to sexual relations while the person is in police custody. Sponsored by Senator Ray Fonseca. Invited testifiers, Honorable Mario M. Brooks, Commissioner, VI Police Department. Honorable Gordon Ray, Esquire, VI Attorney General, VI Department of Justice. Ms. Julie Smith Todman, Esquire, Chief Public Defender, VI Office of the Public Defender. Ms. Anya Stewart, Executive Director, Family Resource Center, Incorporated. Block 3, 1 p.m. to 2 p.m. Bill number 36-0005, an act amending Title 16, Virgin Islands Code, Chapter 2, Section 99, establishing a mandatory minimum bail amount in domestic violence cases. Sponsored by Senator Angel L. Bulkes Jr. Invited testifiers, Honorable Gordon Ray, Esquire, VI Attorney General, VI Department of Justice. Honorable Mario M. Brooks, Commissioner, VI Police Department. Dr. Clema Lewis, Executive Director, Women's Coalition of St. Croix. Ms. Anya Stewart, Executive Director, Family Resource Center, Inc. That concludes the reading of the agenda, Mr. Chair.
Thank you. At this time, I'd like to recognize non-committee member Nobel Francis. Come on. Today, we have 3 bills before the Committee on Homeland Security, Justice and Public Safety for consideration. So let's begin. The testifiers for the first block are ready. Who speaks to this bill?
I do, Mr. Chair.
Second, Senator Gittinger, recognized.
Thank you, and good morning to all. This bill, bill number 36, that's 0036, is sponsored by Senators Novel E. Francis
Hold on one
Jr.
second, Senator Giddens. Hold on a second. Okay, good. I was just going to ask for the media to put you up. Okay, go ahead.
All right. This measure is proposed by Senator Francis Jr., Senator Franklin Johnson, and myself as primary sponsors. As a former law enforcement executive who was once assigned to the Traffic Investigation Bureau, I am personally familiar with the significant challenges our local law enforcement officers face in maintaining safety and order on our roadways. It is with this experience in mind that I bring forward before you today, Senators Francis Johnson and myself, that we bring to you today bill number 36-0036, which seeks to repeal and reenact Title 20 of the Virgin Islands Code, Part 2, Chapter 43, Section 512, with the goal of increasing penalties for traffic violations and establishing a police impound lot under the Virgin Islands Police Department to be utilized by all local and federal law enforcement agencies, or rather all law enforcement agencies. The need for this bill arises from the fact that the fines schedule in the traffic code has not been updated in many years. Our roadways have become more and more congested and traffic violations have evolved. However, the penalties for such violations have not kept pace with inflation or the seriousness of the offenses. This bill proposes to bring the fines for traffic violations in line with the current state of our roads, ensuring that they are appropriate and impactful. Under the proposed legislation, no citation would be less than $100, and the distribution of fines will also benefit various sectors of our community, from each paid citation, $1 will be allocated to the courts for administrative purposes, $2 will be allocated to the issuing law enforcement agency, $5 will support the Police Athletic League, contributing to youth programs and community engagement, and $25 will be designated for the maintenance and upkeep of the newly proposed police impound lot. Also, at the appropriate time, we will also submit it was distributed, an amendment that will allocate, I believe, it's $2 to from each paid citation to the court specifically for the Rising Stars Steel Orchestra. In addition to updating the fine schedule, this bill seeks to establish the Virgin Islands Police Department impound lot. The creation of this facility will assist law enforcement and other affected governmental agencies in maintaining the health and safety of our communities and public roadways. It will ensure that abandoned vehicles are removed promptly and that public safety is prioritized. The impound lot will play an essential role in law enforcement operations and enhance our overall public safety efforts. Under this legislation, the VIPD commissioner will also be tasked with establishing rules and regulations for the administration and operations of the impound lot. We already had this meeting The protocols will be set in place to ensure the safety and security of vehicles in the lot, and these protocols will be updated as necessary by the Virgin Islands Police Commissioner. Moreover, the bill outlines an initial fee schedule which will be reviewed and adjusted as needed by the police commissioner. These fee includes $65 towing services, $35 for daily storage, and $25 for administrative processing. However, during our meeting, we realized that $65 for towing services was not commensurate to the going rate. So an amendment will be offered to increase that from $65 for the towing services to $150 for the towing services. These fees will not only support the operation and maintenance of the impound lot, but also help affected agencies acquire or maintain data-related systems, training, and equipment necessary for respective operations. In conclusion, this bill will enhance law enforcement capabilities, improve public safety, and ensure that our traffic enforcement policies are both modern and effective. However, enforcement is key. I respectfully request your support for this important piece of legislation, and I look forward to hearing the discussion today. Thank you all.
Thank you. At this time, I'd like to recognize my co-chair, Mr. Senator Ray Fonseca, and also in the St. Thomas District, I'd like to recognize Senator Carla Joseph. Good morning, testifiers. Kindly state your name and title for the records. We will begin with Mr. Sergeant Arthur Joseph here. And so begin. Could you recognize Mr. Arthur Joseph, Mike, please?
Good morning, Senator.
Name and title.
Arthur A. Joseph Sr. I'm the commander for the Traffic Investigation Bureau. I'm a sergeant with the Virgin Islands Police Department.
Good morning. I'm Attorney General Gordon Ray.
Good morning. Mario Brooks, Police Commissioner, Virgin Islands Police Department.
Good morning. Sean Santos, Assistant Commissioner, Virgin Islands Police Department.
Morning. Houston Cornelius, Acting Chief of Police, St. Croix District.
St. Thomas District.
Morning. Rael Donistoric, Acting Deputy Chief, St. Thomas District.
Good morning. Deborah Hodge, Acting Police Chief, St. Thomas, St. John, Water Island.
Good morning. Desiree Ritter-Lambertis, Virgin Islands Police Department, Victim Witness Advocate.
Good morning, Sergeant Joyce Lanley Barbach, Commander for the Traffic Investigation Bureau and Commander for the Motor Carrier Unit, St. Thomas, St. John District.
Thank you. At this time, Attorney General Gordon Ray, you could go ahead with your testimony, and followed by Commissioner Brooks.
Thank you. Good morning, everyone. Honorable Senators, legislative staff, and the listening and viewing audience. I'm Attorney General Gordon Ray. It's my pleasure to appear before you today to address proposed bill number 36-0036.
Yeah.
Hold on 1 second.
Point of personal
Attorney General. Point of privilege.
Point of
recognize.
Privilege, Mr. Chair.
You recognize.
I apologize for interrupting, but I asked for it prior to the reading by Attorney General Gordon Ray. My point of personal privilege is to congratulate Lieutenant Deborah Hodge for becoming the first woman appointed Chief of Police in the history of the Virgin Islands. So I just wanted to congratulate her on that accolade. Thank you. Yeah.
Thank you, sir.
Well, I'll make sure before we leave that the Commissioner do her due respect of letting the world know that he was the first, or he and the governor was the first to allow. So go ahead this time, Attorney General. You could continue.
It's my pleasure to appear before you today to address proposed bill number 36-0036. Thank you for including the Department of Justice in this very important discussion. The Department of Justice, the Office of the Attorney General, and the Attorney for the People of the Virgin Islands recognize and support this bill that seeks to update the fines imposed for traffic violations. We also fully support the establishment of a police impound lot accompanied by the fee structure as set forth herein. It's my understanding that a large portion of the traffic citations issued in the U.S. Virgin Islands go unpaid every year. The imposition of higher fines is unlikely to change that. However, it's important that drivers throughout the territory learn and understand how important it is to abide by the traffic laws in order for everyone to traverse the roads and highways safely. The increase in many of the traffic fines should serve as a deterrent to violations of our traffic laws. The inaction of this bill will also provide for the establishment of an impound lot for the Virgin Islands Police Department and associated fees that will be passed on to the registered owner of the vehicle. This is very important, particularly as some vehicles are being impounded as evidence of crime. In those instances, allowing the vehicle to remain outdoors and unsecured allows for evidence to be tampered with or removed from police custody. In particular, should DNA, fingerprints, blood, or other evidence be present in or on the vehicle, it's of utmost importance that such evidence be preserved. The fee schedule included within this bill is reasonable and justifiable, given the nature of the costs associated with operating an impound lot. In addition, providing that a portion of the traffic fines be allocated to the Superior Court, the issuing law enforcement agency, and the Police Athletic League program is a creative and mindful way of generating funds for these projects and tying traffic fines to the Superior Court and law enforcement agencies that enforce the traffic laws. All of these are very worthy agency projects and deserving of the attention that this bill provides. I might add that while the bill appropriates a portion of the increased fees to nonprofits, the bill does not provide startup funding to support the mandated establishment of a police impound lot. Without startup funding to support the costs of infrastructure and acquisition of property, no impound lot will likely be established. That concludes my remarks. Thank you for your time and attention today, and I'd be glad to take any questions.
Thank you. Commissioner Brooks.
Good morning, Mr. Chairman, the Honorable Clifford Joseph Sr., esteemed members of the 36th Legislature, legislative staff, colleagues from the Virgin Islands Police Department, and our attentive audience. I am Police Commissioner Mario M. Brooks, and today my team and I stand before you to express unequivocal support for Bill number 36-0036, an act repealing and reenacting Title 20, Virgin Islands Code, Part 2, Chapter 43, Section 512, to increase penalties for traffic violations and establish a Virgin Islands Police Department impound lot and address other related purposes. We also stand in support of Bill number 36-0024, an act amending Title 14, Virgin Islands Code, Chapter 85, by adding Section 1710, declaring a person incapable of consent to sexual relations while in police custody. Mr. Chairman, distinguished members of the Senate, thank you for the opportunity to testify today on this matter. The urgency of this bill is underscored by the recent data from the Virgin Islands Office of Highway Safety. Regarding traffic citations, the Virgin Islands Police Department Traffic Records Program diligently collects and analyzes data on traffic crashes, citations, and adjudications. The Virgin Islands Police Department observations indicate a troubling rise in violations, which we believe can be linked to the current fee structure. With a focus of fiscal year data, our references will be drawn from FY 2023 and 2024. In FY 2023, officers of the Virgin Islands Police Department issued 6,276 moving citations and 875 parking violations across the territory. In 2024, officers of the Virgin Islands Police Department issued 7,294 moving citations and 1,216 parking violations across the territory. Although the Virgin Islands Police Department has been consistently increasing our issuance of citations to mitigate these violations committed on our roadways, the increase clearly shows that despite having penalties in place, there are those who continue to operate motor vehicles with wanton disregard across our territory. But more impactful than the citations are the crashes and the fatalities caused by reckless and disrespectful behaviors of some of our motor vehicle operators. There were 5,084 crashes in FY23 and 5,037 in FY 2024. The island of St. Thomas, unfortunately, continues to be the leader in the number of crashes, with 3,125 and 3,070 respectively. St. Croix follows closely with 1,713 and 1,708 respectively, and St. John with 246 and 258 respectively. The number of fatalities recorded in FY 2023 were 12, with an equal number of 6 on St. Thomas and St. Croix. In FY 2024, there were 7 fatalities recorded, 4 on St. Thomas, 2 on St. Croix, 1 on St. John. But FY 2025 is a crushing year thus far, with 9 fatalities, of which 8 occurred on St. Croix, and the other fatality occurred on St. Thomas. Crashes and fatalities in the territory often indicate that many of the vehicles on our roadways contain unrestrained occupants. Title 20 of VIC 466 states that all occupants in a moving vehicle must wear a seatbelt or use proper child restraints. The USVI usage rates for calendar year 2024 was 71%, which is significantly lower than the national average of 90%. There were 195 and 207 unrestrained drivers involved in crashes in 2023 and 2024, respectively. Of these unrestrained drivers, 5 lost their lives in FY 2023 and 2 in FY 2024. In FY 2023, the territory recorded 101, and in FY 2024, the territory recorded 80 crashes which involved drivers impaired due to alcohol and drug abuse. In FY 2023, there were 26 drivers involved in those crashes with a blood alcohol content higher than the lawful limit. In FY 2024, the number of crash-related drivers with a BAC higher than a lawful limit of 20. Alcohol use and drug use, prescription or otherwise, should not be combined with the operation of motor vehicles on our roadways. The results can be devastating to family, friends, visitors, and members of our wider community. In FY 2023 and FY 2024, there were 65 and 61 pedestrian motor vehicle crashes, respectively, 8 and 3 bicycle vehicle crashes, respectively, 227 and 233 commercial vehicle crashes, respectively, and 42 and 66 motorcycle crashes, respectively. Of these types of crashes, there were 2 pedestrian fatalities recorded for each of the fiscal years. 3 motorcyclist fatalities in 2023, 1 for 2024, and thankfully 0 for bicyclist fatalities during those periods. These statistics highlight the persistent threat posed by the actions of reckless and disrespectful road users. We all share the roadways, and VIPD is requesting your assistance in increasing these fees and fines to prohibit levels to protect all road users. In addition, the establishment of impound lots on both St. Croix and St. Thomas is a critical component of this legislation. Currently, the absence of a dedicated impound facility poses significant challenges for vehicle storage and security. Vehicles involved in violations or accidents are often left to private towing businesses to secure in minimally secured areas, raising concerns about price gouging, preferential treatment, vandalism, theft, and public safety. Often this is coupled by steep unregulated towing and storage costs, as well for the community to absorb. By creating secure impound lots, we ensure that vehicles are stored safely until they can be retrieved by their rightful owners, thereby enhancing community confidence in our law enforcement processes. We have already begun the work on preparing both locations for service. In addition, the Virgin Islands Police Department has recently acquired several records, which will be utilized to support this initiative as well. We are extremely grateful to the sponsor of this bill for the foresight to support this endeavor for the Virgin Islands Police Department. In conclusion, the data presented today underscores a pressing need for legislative action to address traffic violations and enhance roadway safety in the Virgin Islands. By increasing penalties for traffic infractions and establishing secure impound facilities, we take a significant step towards safeguarding our community and reducing preventable tragedies on our roads. I urge this esteemed body to pass Bill number 36-0036, reinforcing our collective commitment to safety and the well-being of all Virgin Islanders. Thank you for your attention and dedication to this critical issue. We stand ready to answer any related questions that you may have.
Thank you, Commissioner. Colleagues, we will begin with a 4-minute round. I'll call out the order as we proceed. Angel Bocas, Senator Angel Bocas Jr., you'll be number 1, followed by Senator Avery Lewis, followed by Senator Dwayne DeGraff, Senator Franklin Johnson, Senator Nobel Francis Jr., Senator Ray Fonseca, Senator Carla Joseph, and Senator Kenneth Giddens. So at this time, the floor, could you recognize the mic of Senator Angel Bocas, please? For 4 minutes.
Thank you, Mr. Chair.
4 minutes.
Good morning, Mr. Chair. Good morning, colleagues. Good morning to the listening and viewing audience. And good morning to the Attorney General of the Virgin Islands, along with the Commissioner of the Virgin Islands Police Department and the leadership team. I wanted to start off by asking a question to the AG based on his testimony. He stated a large portion of the traffic citations issued in the Virgin Islands usually go unpaid every year, and that higher fines alone are unlikely to change that. Can you elaborate on what additional enforcement, if any, or administrative mechanisms you believe are necessary to ensure the higher compliance of the payment of these fines?
Well, I would think that, again, I haven't looked into that issue, so I would have to just speculate at this stage, but I would think that if people aren't paying the fines, there should be a record of that. And there should be follow-up. And obviously, failing to pay a fine is going to be an actionable offense in its own right. I think it would be possible to set up a system so that that could be reported to Justice Department, and we could then proceed with basically a collection matter.
Right, and I asked the question because I'm not particularly against what is being proposed, as we know that it has not been changed or updated in quite some time. However, I think a part of the solution that we're trying to endeavor upon requires additional enforcement and administrative mechanisms in order to find a solution, because even though we may raise, particularly individuals may still yet not pay. So I just wanted to at least mention that on the record. And Commissioner Brooks, good morning.
Good morning, sir.
You mentioned in your testimony, good morning, sir. You mentioned in your testimony in fiscal year 2024, the VIPD issued 7,294 moving citations, which was up from 6,276 in fiscal year 23. Yet the violations remain high. What factors, if any, do you attribute to this rise?
I'll start by simply saying the fees. We have individuals that will just pay the fees. They just don't care. Give me the common term is just give me my ticket and let me go. That's just the reality of it all. Those fees have been there for quite some time. I'm talking about years. Those fees have been stagnant at that rate. I think it's high time that we raise those fees. And we start to impose them. Enforcement is something that we continue to do. I know that the common theme is that enforcement is at a low, but I can assure you, look at the numbers. The officers are issuing citations. Sometimes we're running out of ticket books. I'll let Commander Joseph speak to some of the enforcement. If you're okay with that, I'll have the commander speak to some of the enforcement when it comes to issuing of those citations.
Thank you, Commissioner. Senators, good morning, everyone. Sergeant Arthur Joseph, Commander for the Traffic Investigations Bureau. As stated by the Commissioner, we constantly on a daily basis enforce the traffic laws here in the territory. And I'm extremely proud to admit that I support the current changes and the bill by Senator Kenny Gittins, Senator Nova Francis, and Frankie Johnson in increasing the fines. The fines, like the Attorney General said and the Commissioner have voiced, will, of course, change behaviors. I think when folks travel abroad and you commit an offense, if let's say you rent a car and you find out that the fine for seatbelt is going to be $280, you wear your seatbelt. The fines are not just act as a deterrent, but will help save lives. And one of the biggest issues, some of the fines that we issue often is seatbelt, which is under 466. And we see that will impact traffic crashes as well. Every day you will see my officers out there enforcing the traffic violations. But like the Commissioner said, the fines are so low that people just prefer to just take the fine and move on, not changing their behaviors. And we believe this change in the law will, of course, help change behaviors, and coupled with an educational program that under Commissioner Brooks will try to implement to ensure people are aware of what the fines are going to be if they, in fact, commit the offense. We have to remember that folks don't have to receive a fine, but what we expect you to do is to comply with the law, so you may never have to pay any fines on this particular schedule once you comply with the law. Thank you very much at this time.
Thank you for your response. And Mr. Chair, may I just have one last wrap-up question, Mr. Chair?
Yes, go right ahead to wrap up.
Thank you very much, Mr. Chair. This question is for the Attorney General once again. He made a very important statement in his testimony concerning the impound lot for securing evidence in criminal cases where vehicles are left outdoors at risk and evidence being tampered with or potentially removed, or under the auspices of nature where evidence can disappear. For the Attorney General, could you share any examples or instances where critical evidence was compromised due to the lack of any secure vehicle storage? As long as that doesn't have to do with a current case or anything like that, you don't have to get into full details, but I think that that statement in your testimony is a very, very important one as we move forward in deciding what we're going to do with this current bill before us. And thank you, and you may respond on the chairman's time.
Yes, I can think of several examples. Again, if a vehicle particularly was used in any sort of a criminal enterprise or offense, then there's all kinds of evidence that can be in there. And if we don't have the vehicle safeguarded, we may well lose that evidence. For instance, there may be blood splatters on the seats. If someone discharged a firearm from within the vehicle, often we can show at least that a discharge was made from within the vehicle by the powder stains, et cetera, within the vehicle. There can be cartridges that are expended in the vehicle. It goes on and on and on. I'm sure you can imagine all of the different instances in which this could be absolutely critical to prove a case.
Thank you, and point of information, Senator Johnson, you're recognized.
Good morning. Thank you very much, Mr. Chair. I just want to do a little follow-up here. I kind of understand that from the previous speaker. If someone get a citation and they refuse to pay that citation, can they register that car the following year?
The process currently, that's for me, Senator Johnson. Thank you, Sergeant Arthur Joseph, Commander for the Traffic Bureau, St. Croix District. The process currently is, once you're issued a citation, the citation is then taken to the AG's office. The AG review the citation and file the citation with the Traffic Division of the Superior Court. Right now, because of the changes that had taken place between the relationship between the courts and the Bureau of Motor Vehicle, the process is pretty quick now. When a judge hears the traffic case and you are not present and a lien is put on, then that automatically goes to the BMV once the judge has adjudicated that citation and a lien is put on your car, so you cannot register the car unless you either go on the court's website and pay the fine, or you go back to the cashier at the court and pay the fine. Then the courts would release the fine, the lien on your car, and then you may register the car.
Just a follow-up. What about a transfer? Suppose I got a ticket, didn't pay it, didn't go to the court, do anything. Can I be able to transfer that car, sell it to someone without those citations being fully paid?
I would say you should not be able to transfer the car because that fine would lock the BMV from doing any process relative to that particular vehicle.
Thank you very much, Mr. Chair.
Thank you. Now, I recognize Senator Avery Lewis for his 4 minutes.
Thank you, Mr. Chairman. Good morning, colleagues. Good morning, testifiers. Good morning to the listening and viewing audience. Before I begin, I'd first like to say, I want to say publicly thank you to Mr. Neville Champi Amy for a well-run Little League tournament this weekend. I think the name was Showdown in Paradise. Congratulations to them. And I'd also like to join everyone in here with the sentiments to congratulate Lieutenant Deborah Hodge on her promotion or appointment as police chief. I thought it was confirmed. I hear it's a little acting part. We're going to chop it off sometime this afternoon. Congratulations, Lieutenant. So, being that Lieutenant is recognized, the first question goes to you. The Commissioner stated in his testimony today regarding traffic citations, the Virgin Islands Police Department Traffic Records Program diligently collects and analyzes data on traffic crashes, citations, and educations. The department diligently analyzes its data. So my question this morning is, what are some of the plans, long-term and short-term plans, to go along with the deterrent of these increases here today? What are the operations, the day-to-day operations? What are some of the short-term and long-term plans?
Good morning, everyone. Acting Chief of Police, Deborah Hodge. So what we currently have are initiatives, traffic initiatives that are ongoing. We have one that's being done by the Special Operations Bureau, and we have initiatives that are being done by the Patrol Division, in addition to the ones that the Traffic and Motor Carrier Department does on a, how often do you do them? Like every month?
Every month.
They
every Saturday.
select either a DUI initiative, a seatbelt initiative, so on and so forth, based on the statistics.
Commissioner, would you say this is going to be ongoing in both districts? Should I see more police presence, more amping up? Explain to me, expound on that a little bit, please, Commissioner.
Yes, Senator. So thank you for that. So what the chief alluded to is actually correct. So one of the things when taking the helm, we had meetings and we talked about using a different strategy when it comes to policing. One of that is DDAT. It's called data-driven policing, right? So we use the data to drive a lot of our operations. So as you can see from the data, and we have a lot of it, we're utilizing that data to direct a lot of operations, namely on the roadways. As it stands right now, I keep saying guns don't walk, guns walk. Guns are transported in vehicles. Yeah. We have individuals that want and disregard, as I mentioned in my testimony, for the traffic laws. They don't want to stop any traffic lights, especially those bikes, the cycles. We have initiatives targeting all of that. So, and I use the word targeting. I know some people might tell me that's wrong. Don't use that word, but we have to stop it. As you can see, we're losing lives as well in this when it comes to related to these type of events. So in both districts, the traffic entities are focused on addressing our traffic infractions. It is something that is is ever growing. It has not reduced in the last few years. It continues to increase. We have individuals. We've seen an increase in speeding. We've seen an increase of crashes, as I just mentioned. We've lost lives. We've lost 9 on St. Croix. 9 territorial thus far, 8 on St. Croix alone. So we can't afford that anymore. We need to step it up.
So, Commissioner, one of the things I really pride the Virgin Islands Police Department with is that I know you all do a good job with educating to me while regulating. And I want you to continue that campaigning of educating the community.
Thank you.
Commissioner, my next question is, you feel comfortable with the fee schedule, the new fee schedule proposed?
Yes.
Good.
We have to do it gradually.
I like that. Commissioner, your Office of Highway Safety, how does the leadership feel? Do you think you can do more programs in the community to deter these type of violations out there?
We can always do more, Senator. And I thank you for that question because that leads me into the ad campaign. So today with us as well, we have our media director, Mr. Drade, and that's one of the things we've talked about, increasing our media presence on the out on social media, particularly speaking about speeding, usage of seatbelts, sleeping and driving, being tired. DUI, we so focus on DUI, we also forget that people get tired while operating vehicles. That's another thing. So our focus on the roadways is to reduce the amount of not only violations, but the number of crashes that we have.
Yeah. Mr. Chair, if I just have one more wrap-up. And
Go ahead and wrap up.
Yes. Commissioner, to you, either you or your chiefs, one pet peeve I have, I'm going to put this on the record here. And I hope we could get this solved or come up with an idea collectively, collaboratively as well. These guys out there in these motorbikes that's not wearing helmets and in and out of traffic daily, whether it's, I would like to see the department really, really crack down on this. I think out of those fatalities you talked about, probably 2 or 3 was because of no helmets. And the one that's expired in St. Thomas about a week ago, condolences to him and his family. But, Commissioner, we have to do something about this. This is really egregious now. And, I know, speaking to a couple of officers, there's a rule that we can't give chase or whatever, but we have to do something. I mean, I listen for your feedback, either from you or any one of the chiefs in the district.
So what I'm going to do is I'm going to actually let both chiefs speak, starting with Chief Cornelius, speak to the initiatives, speak to basically the operational plans as it relates to these type of events that you're mentioning. Chief Cornelius.
Good day, sir. Cornelius, St. Croix District. In terms of your concern, what we are doing right now, we are reaching out to the guys that are riding these motorcycles. And also while doing that, we are speaking on the inside and outside of talking to them, when we see them at the different areas fueling up and doing what they need to do to prepare to ride, we will, after we speak to them, do our enforcement, impound, and without the paperwork that is needed to get them back, they just won't get them back after we do our advising to them.
Chief Hodge?
Yes, our current special operations initiative is addressing that concern. As a matter of fact, we have several motorbikes that are giving us some issues as far as where we're going to store them. So we are in fact addressing them, not because the policy gives restrictions mean that we are not able to make or attempt to make those stops. So officers are encouraged to continue to make those stops and address those infractions.
Thank you for your responses, and I do believe that the community would be relieved to hear those responses this morning. Thank you. Thank you, Mr. Chairman.
Before I go on to the next senator, which is Mr. Senator DeGraff, question I have myself is, when was the last time the traffic violations were increased?
Senator, and I've been in 30 years, I can't recall the last time they were increased. They needed to be updated for quite some time. And I really applaud the senator for pushing this for us.
Thank you. Senator DeGraff, you're recognized for your 4 minutes.
Thank you, Mr. Chair. Good morning, colleagues. Good morning, testifiers, all of you listening and present. Mr. Chair, you're doing a great job. Keep doing what you're doing. Commissioner, this acting stupidness got to stop. No disrespect, but I don't want to hear our top leaders acting. I mean, you know, Academy Awards coming up, but geez. So how soon could we see these chiefs and deputy chiefs be sworn in? Do you have a date?
I don't have a date, Senator, but I can assure you it's in the works. The last discussion I had with my boss was that it's coming shortly. Believe me, I don't call them acting at all. If you notice, I call it chief. These are my chiefs and my deputy chiefs and my acting and my commissioner, assistant of commissioner, my deputy commissioner. They are not acting for me. They're working. So. Okay,
great. You know, I too support this bill. I'm going to be signing on to it, and the sponsor of the bill asked me to present an amendment to it, so I'll do so with honor. But looking through the bill and being an old police officer, negligent driving and reckless driving, I think they have it wrong inside. Reckless driving is a misdemeanor. Negligent driving is a fine. So if you have a negligent driving with personal injury $1,000, and you have with property damage, you have $750, you have reckless driving $300, something wrong. So let's go through these things again and get it right the first time. Because reckless driving is a very serious offense and it's a misdemeanor. If I'm wrong, I could be corrected. I stand corrected, but I don't know if it was changed. For Commissioner, do you have an impound on both islands now at all? Because I know you had one on St. Thomas. I don't know if you had one on St. Croix. Do you have them at all?
So we have two areas identified. Through Senator Gittins, we identified a location here in St. Croix. We have already begun our assessment of that area so we could start to do the work in preparing it for action. And on St. Thomas, we had a previous location we're going to utilize. It's not the most ideal location, but we're going to make it work until we can find another location. We require lighting, security, fencing, 24-hour coverage for security, and so forth. So we're working on that as we speak.
And as Attorney General Rea mentioned, you know, we write in these violations, and so the PD is doing enforcement, but then as Attorney General mentioned, they're not being, a lot of them not being paid. Is that factual, Attorney General? You have the data on that? As to how many of these 5,000 and 7,000 citations are being written and are not paid?
I do not have specific data with me now. That information was given to me by 2 or 3 different people who are involved in the traffic-related issues, but I do not have the data. I'll be glad to get that for you.
Oh, okay. Yes, if we could get that through the chair, requesting the data on how many of these fees, violations are being filed in the court and not being paid. Because again, when people talk that the Vernon Police Department ain't doing anything, they ain't doing their job, but to hear you write 5,000 citations and 4,000 and 1,000, 1,000, however much, and then to hear that they ain't being paid, then I don't think that's VIPD dropping the ball. So I think rather than pointing any fingers, you know, that's some data we need and address that. So again, finally, Mr. Chair, continue doing the job you're doing. Congratulations to the Virgin Islands Police Department police chiefs and deputy chiefs. Drop acting. Thank you, Mr. Chair.
Point of information. Point of information, Avery. Senator Lewis, you're...
Based on a line of questioning from the previous speaker, Commissioner, do you have any data as to how many of your citations were actually prosecuted or anything?
I don't have that data with me present, but we can get that information for you.
Thank you very much.
Point of information.
Point of information, Mr. Chairman.
Senator Joseph, you're recognized for your point of information.
Thank you so kindly, Mr. Chairman, and a pleasant good day to everyone. My point of information is to follow up on the response that the gentleman from Savan received from the commissioner relative to the location of the impoundment, and they're considering. Where is it located in the St. Thomas district? You didn't clearly indicate that in your response to the gentleman from Savan in his questioning.
Senator, I did not clearly indicate it for purpose. I can give you the information offline.
Okay, understood. Thank you so kindly.
Point of information.
Where?
Point of information, Gittins.
Oh, Senator Gittins, you're recognized.
Yeah, I know you forgot that I'm online. My point of information is that with regards to the testimony and the ongoing responses from the Attorney General's office regarding citations not being paid, if that's a matter of fact, then we need to touch base with the courts, because what should be happening is that there should be liens placed on these vehicles once a fine is not paid. But I don't want us to go through the hearing just stating without facts that people aren't paying the fines. Once these matters gets to the courts and an order is given, it must be paid. And if it is not paid, then liens are placed on the vehicles.
Thank you, Senator Giddens. Attorney General Ria.
Yes, sir.
Can you please clear up the issue with reckless and negligent driving that Senator DeGraff mentioned, so we can be sure that the bill is correct?
We will take a close look at that and get back to the draft of the bill. Yes.
Okay, thank you. Now recognize Senator Franklin Johnson for your 4 minutes.
Good morning. Thank you very much, Mr. Chair. Good morning to my colleagues. Good morning to the testifiers. Good morning to the viewing and listening audience. And before we go too far, I just want to say thank you to Commissioner Brooks and his team taking part with me and Senator DeGraff and that gun buyback, which brought in some 60 weapons. And we must say kudos to that. We did this before under Commissioner Vellenor, and we did 4 events. 2 on St. Croix, 2 on St. Thomas, and we netted 30 weapons. In 1 event on each island, in St. Croix, we netted 27, in St. Thomas 30, and this weekend we've been in St. John and we picked up 3 weapons. And every weapon off the street makes a big difference. So I want to say thank you, Commissioner Brooks, to you and your team for a job well done, and we definitely going to go back to the table, go back to our supporters, business folks who are just donating money to make this happen and do it again and do it even bigger. So I want to say thank you to you guys for that. I want to start off with my line of question, Commissioner, and on page 3 of your testimony, you spoke about 9 fatalities, which 8 occurred in St. Croix. But on page 4, you didn't indicate how much of them was motorcycle or RTVs. You indicated on for 2024 that we had no fatalities by motorcycle, but you didn't indicate how many motorcycle fatalities we had in 2025 thus far. By any chance, you have that information?
Not on me, I can get that for you.
Because from one of my previous speakers, I think he said that we had 1 in St. Thomas, and I know we just had 1 on St. Croix. Yeah. Was those 2 part of your 9 for the 2025?
Yes.
If you can, if we could get that information, I'll greatly appreciate that. And then traversing throughout the territory on the island of St. Thomas, I see these very large RTV. I might got a wrong name for them, but they're the bigger, they're not so much off-road, they're permitted on the road. And on the island of St. Thomas, I see that they're registered with license plates. But I haven't seen that on the island of St. Croix. And I've been to St. Thomas this weekend, and I saw some of those vehicles. What seems to be the difference here? Why on the island of St. Thomas, I'm seeing them registered with license plates, which I'm glad to see that. but I'm not seeing it on St. Croix.
I'm unaware. We're talking about the ATVs with the four wheels. That's
But these are some big ones that could hold like 4 passengers.
Side by side, it looks like cars, like small
Yes.
cars. Yeah, I'm not sure. We'll have to have a discussion with the BMV director relative to if there's a discrepancy there, or maybe it's just a business on St. Thomas that actually rents those. I think that's what it was. But we'll get back to you with an answer on that.
Chief Santos, you have any information you could share with me?
Yes, Senator. So we did do a campaign. As Acting Assistant Commissioner Sean Santos. We did do a campaign last year in regards to being able to register side-by-sides. It appears that after that campaign, that public announcement campaign was done, a lot of these side-by-sides have been being registered. So far on the island of St. Croix, I've probably only seen one that has been registered, but it is open to go into the BMV to be registered. They can go and register their side-by-side vehicles once they fit the criteria within the Virgin Islands Code.
Thank you very much for that, because it's important that some of this information get out, because some people are driving, and then, you know, I received some call, and I said to folks, that's not true. Some of these guys are riding these bikes saying that they can't get insurance for them. Anybody have any information to follow up on that? Because I know we have ours insured bikes. Now, it's come across. When you have these fatalities continuously happening on these motorcycles, insurance company gonna ask for more money.
Time.
So is there any truth to that, that they can't get insurance? And any of you guys have any knowledge of that by any chance?
I don't, Senator.
Thank you very much. I have a few more questions, Mr. Chair. I'd like to just ask at least one more.
You could ask one more to wrap up.
Thank you very much. And I need for the chiefs or even Sergeant Joseph to respond to this, because for some reason people believe that increasing these fines are not going to reap benefit of people complying. But I want for you to explain to folks some of what you go through when you try to give these $10 and $15 fine. What are some of the response some of the people said to you when you issue these citations? And because this is something that needs to be said, because I don't think people understand when you go with a $10 and $15 fine, somebody might just tell you what they need to tell you. And just in layman terms or in more professional terms, explain to us what are some of the things that you're incurring when you're giving out these small fines.
Good morning once again, Sergeant Arthur Joseph, Commander Traffic Investigations Bureau. Thank you, Senator Frankie Johnson, for the question. The updated fines that that this body should pass, some of the things that we hear from the motoring public when we issue the citations is that I get these all the time and I can pay that. That's nothing to me, you understand? But what we want people to really understand about these updated fines, this is about making sure that not just based on what Senator Giddens have elaborated on before, but we want people to understand that the fines are about deterrence. There are a lot of good, hardworking people that wants to come in compliance with traffic laws. But we just can't make people believe that updated fines is the end of it. We must couple that with education. People need to know that this body passed in 2022 Act number 8682, which allows all vehicles. They changed the definition. We changed the definition of vehicles. So ATVs, whatever you have that's motorized, according to the Act, can be registered, and so it can be insured. It's just that people are bringing them into the territory, and I think maybe if we do more education from the shipper standpoint, from reaching out to people like you do with your gun buyback program, and talk to them about the importance of registering their vehicles, insuring their vehicles. So if there's a crash, it's not just protecting you, but protecting the other person. That is mandatory under Title 2708 of the Virgin Islands Code when it comes to insurance. So it's important that we educate folks, not just about the updates, but about the importance and that the importance when it comes to registering and insuring your vehicle, because you're protecting everyone, including yourself. And sometimes we have children that are involved in these crashes. You're protecting your children when you insure your vehicle, and your registration is really about making sure you comply with the Virgin Islands law so that we can fix the roads. We can pave them, we can stripe them, we can put up signs, when we register our vehicles. So that's what really we're trying to convey to the listening public.
Mr. Chair, I need to follow up based on something this Mr. Sergeant Alder Joseph said, because for me it's important.
Continue.
Anytime someone bring in a motor vehicle, a car,
right,
through the piers, you can't leave the pier with that vehicle unless you actually go and get permit.
That's correct.
Insurance.
That's correct.
What needs to be done to make sure the same thing happen? If there's some laws need to be adjusted to make sure that the same thing happen when these bikes, because what you said just kind of hit a vein for me. People bringing these bikes, they come through the same shipping port, and here it is, we have laws where they can be registered. Do we need to do something, adjust the laws, or we just need to make sure that the shipping company them is aware of these laws, that these vehicles, these off-right road can be registered and insured, and they should go through the same process with when someone bring in a car?
I'm smiling because several years ago, I was the special assistant to Delroy Richards. And we met with IRB at the time, and we were on BMV, and we had this discussion about ensuring that no vehicle, in my opinion, should leave the ports unless it's registered. And this is because when you give someone permission to move the vehicle from the ports to their home, or from the ports to BMV, BMV may be closed at the time, so they can't get it registered that day. What is happening is some people feel that, okay, they give me a permit to move it, I could just drive it without the plates. What if that vehicle is used in the commission of a crime? We have no information. If that vehicle is involved in a hit and run, we have no information to find that individual who just left the dock with that vehicle and move it to their home. If we change the law to require that once a vehicle touches our soil in either district, it must be registered. That is possible, and it should be done so that we don't run ourselves into the situation where now they come in and they bring the bike in. The bike now is on the road, unregistered, the motorcycle or whatever vehicle you have, unregistered or uninsured. It should be mandatory from the time that vehicle. And you could do your exemptions when it comes to individuals who are bringing in a large number of cars, like the car dealerships. You can make the adjustment for those. But individuals bringing in vehicles, it should be registered and insured before they leave our ports.
Thank you very much, Mr. Chair.
I hope that answers your question.
Sure did. Thank you very much.
At this time, the Commissioner would like to respond as well.
So, no, I really like to, Senator, have both traffic commanders, that's Sergeant Joseph and Sergeant Bob, and St. Thomas, speak to the motorcycle fatalities for this FY. They would know, they have that first-hand information.
You recognize?
Thank you, Sergeant Arthur Joseph, Commander Traffic, St. Croix District. Currently, I will have to look it up in my book here, but we are aware of, at least in the District of St. Croix, one fatality involving a motorcycle. We've had other injuries involving motorcycles. And that's an unfortunate, so our hearts and our minds and goes out to the families of those individuals who have succumbed to their injuries as a result of these motorcycle crash. We want to prevent more of these. And the way we can do that is by updating our fines and educating individuals on the importance of operating motorcycles or ATVs using the appropriate protective equipments like helmet and body armors that you can wear. Because a crash with a vehicle is almost certain that it's gonna be fatal. And so we want to educate folks to reduce their speed when operating not just motorcycles or ATVs, but operating vehicles as well. And so we want everyone to be safe. We don't want one to leave their homes and not return home when you're operating any of these equipment. And I want to put it out there, Senator, if I may, Commissioner, please don't put children on these vehicles. They're not designed for children to operate. Children should not be operating these motorcycles and these vehicles, regardless of their skill sets. And we see it all the time. We currently have another case that occurred in Frederickstead, and our hearts goes out to that family where the individual is not, we don't know if they have but they're not doing well. We don't know what's the status right now, but it happened on close to Dorsch Beach. The individual was on an ATV, and he was seriously injured. And like I said, the family, it's a real financial burden when someone is injured and they have to fly their family members out. It can really tear a family apart and actually put you in a very financial, terrible, terrible situation. So we ask that, we minimize those things.
Yeah. Sergeant Bob, St. Thomas.
Good morning, Sergeant Joycelyn Lee Bob, Traffic Investigation Bureau. This year we have one fatality, but it's not a motorcycle. Last year we had a motorcycle collision. However, the person expired this year as a result of that collision.
Point of information.
Point of information, you recognize Senator Avery.
I know my name. I don't worry with it. Commissioner Brooks, while we're on the topic of fines and fees and so forth, there's another problem brewing in the territory where we have individuals, when they knock into or collide, whatever we want to say, or destroy government property. What is the current process, or what do we do about that currently? What happens? Who could expound on that for me?
So, and I know exactly where you're going with this. We've had that happen several times over the last 3 years. Mm-hmm. So once that occurs and the investigation is conducted by our traffic investigators, a copy of that report is sent to Public Works. Public Works Commissioner, they take over from there to reach out to the necessary individuals to have that addressed. So we've had several situations, particularly on St. Thomas. We've had that issue a couple of times right on the promenade. I know that's where you're going with it.
Good. So I think I'm bringing some legislation forward to address that.
Yes.
Because too far, many times we have people destroy different things, and then you hear the same community saying, "What about the guardrail? What about different things?" And knock down signs and so forth, and it's all left on the government. So we need to start going after the individual, or all vehicles should be registered and insured. So we need to start taking the proper action.
Yes, we'll support that bill for
Thank you.
Yes.
Point of information.
At this time, I'll recognize. Point of information, Senator DeGraff, you recognize.
Thank you, Mr. Chair. To Sergeant Joseph, I think you mentioned about vehicles being on the road that we don't have information on. So you're saying if a vehicle comes from the States that is bought, the individual can leave the facility, the shipping company yard, without any kind of documentation from the police department or from BMV?
What I said, Senator, thank you very much for your question, Sergeant Arthur Joseph, Commander Traffic St. Croix District. When someone brings a vehicle into the territory, you pay for the shipping costs to the shipper, and you go to BMV with the appropriate documentation to ensure that you can move the vehicle. The vehicle is not being registered at that time. That information is not in a system where we can identify readily. The vehicle does not drive off from the docks with plates. So no, we do not have any information that we can readily access to determine who owns the vehicle. We don't have that information once that vehicle leaves the port. And what we've seen more often is vehicles leave the port. Let's say I buy a vehicle in Nevada, and I come now with the Nevada plates on the vehicle. Once BMV gives you that permit to move the vehicle, you're being authorized by them to take the vehicle home, and then you're supposed to come down to BMV to register that vehicle. Now, some folks take the opportunity to continue to drive the vehicle with the Nevada plates. Now, we have to do the stop. I'm saying to you, senators, that if that person lends that car out to someone who has not the best interest here in the territory and decides to use that in a commission of a crime, we have a vehicle that, with the only thing we know, it's a Nevada plate. We cannot go to a system for BMV and determine who's the owner for the vehicle. And so I'm asking that, and that when I spoke to Senator Frankie Johnson's question, it was to try and close that gap so any vehicle that comes into the territory is registered immediately. So once they move from the dock, we are aware who owns the vehicle and that the vehicle is registered and insured.
Okay, I guess we could look at that, but again, the shipping company would have that information, even if it was sent as a fleet of vehicles. All of that documentation is bill of lading, information is given to BMV, so they would have that information. But you're saying something more clearly defined, we may have to put into law. But again, we could look at it. Thank you for the time, Mr. Chair.
Thank you for your question.
The question I have for the police department is, there are dirt bikes that wouldn't be registered. So how would you track from the public safety to into the community? Because they don't have paperwork to register. And those are some of what we've seen on the road today. So what do we have in place to address that situation?
So, Senator, is the same concerns that Sergeant Joseph just mentioned. There's no mechanism in place outside of once that vehicle, whether it's a four-wheel vehicle or a dirt bike or any type of cycle, enters the territory. There's nothing mandating them, to Sergeant Joseph's point, to register that vehicle before it hits the roadway. Once that paperwork is received, a bill of lading, and they pay that road tax, when they leave there, they're basically free to leave. They're told that they need to take that vehicle to the inspection lane to be inspected and licensed to go on the road. But the point is, 9 times out of 10, I can assure you that there are those that will not do that. They will not do that, and those bikes will be on the road. So we need a mechanism in place that addresses that.
We work on that mechanism. I just want to make sure. I was really trying to get to the ones that are off-road vehicles, because off-road vehicles, then we'd have to have a mechanism in place, just like with a tractor or a backhoe, to make sure they're off-road. They should be off-road. So we'll have a person being registered too. So even if they're going to be using it for, as mentioned, for off-road, we'll know for sure when you stop it who it belongs to.
Right, and the license should reflect that as well.
We'll work on that, because some of those are not going to be registered. Am I right?
Well, Commissioner, thank you, Sergeant Joseph. That's correct, Senator. Currently, because of there's some things going on, vehicles come to the territory in crates, because I work closely with CBP as well. And so they don't necessarily come through the container port. They may come in crates, 3 and 4 of them in a crate. And so they don't necessarily go through the process. You come, you pick them up, and you take them home. So there's no permit being issued by BMV for those vehicles because they came in a crate. And so what we have to do is make sure that, based on the definition that the legislature has passed, that once you meet that definition, you have to register them. Even if they come crated, they must be registered. Now, the ones that are off-road, still based on the definition and the Act number 8682, has to be registered as well in the territory, so that when something occurs, because you can't expect people to drive them off-road alone, and they don't. As a matter of fact, most of these vehicles that we have defined as vehicles, the manufacturers, if you look at some of the titles, the manufacturers tell you that they are not to be driven on asphalt. They should be driven only off-road, because the tires don't have those tractions to be on the asphalt or on concrete. And so they have shielded themselves. And so when you see a dirt bike on our streets, you can look at the title for those vehicles, and the manufacturer is telling you it's unsafe for you to use that. So if someone gets hurt, you can't sue them. And so while each state makes its own definition for what a vehicle is, off-road vehicles, based on the law, should also and can also be registered and insured. And we want them to do that, so when something happens, we can find the owner and hold someone not only from a traffic violation standpoint, but from a civil standpoint as well. We can hold somebody liable.
Thank you for your answers.
Thank you, Senator, for the question.
Could you recognize Senator Carla Joseph Make for your 4 minutes?
A pleasant good day. Again, colleagues, testifiers, and the people of the Virgin Islands, I'm really pleased with the conversation that we're having today on Bill number 36-0036. I do have some question and just one major burning question, and it's regarding the impoundment, and I believe it was stated by the commissioner, Commissioner Brooks, and I'm on, I don't know what page this is, the pages aren't numbered, but anyhow, it was stated in the absence of dedicated impound facility poses significant challenges for vehicle storage and security. Now, because apparently when you have vehicles, based on your statement and that follows this, basically when you have vehicles that were impounded by the towing companies, there were some issues regarding the towing company because they were being impounded by the towing company's private impoundment. Were you encountering, or our citizenry encountering issues with those vehicles being stored there because of various violations, meaning that there were some issues that arose with those towing companies in their storage facilities?
Thank you for that question, Senator. And the short answer to that is yes. We've had a myriad of complaints from citizens about the storage of their vehicles when they've been impounded by private companies. So what I'll do is I'll have both traffic supervisors, commanders speak directly to that at their experiences that they've had encountered when it comes to these type of situations. Start with Sergeant Bob and St. Thomas.
Good morning, Sergeant Joyce and Lead by Traffic Investigation Bureau, St. Thomas and John, Water Island. Many times when we encounter, like we go to a collision and we call for a wrecker, some wreckers, when they go with the vehicles, they charge them exorbitant amount of money to remove their vehicles. If their vehicle is a rollover, sometimes they want to charge them more, like $1,000. And then when they store it, they want to charge them like $50, $60, you know, in pound fee. So it's not regulated. All record drivers charge different amount of money. And when they store it, sometimes you could tell them, pick up a vehicle, they carry it over Red. If we picking up vehicles in Red Hook, they'll take their vehicle over Red Hook in the yard, drop it off, and then go and pick up a next vehicle. So it's not secured over where they dropped it. You know, so somebody can still go and get their vehicle. So that's what we are encountering a lot in the St. Thomas St. John Water Island District.
Okay. Thank you so much for that, Sergeant Joseph.
Thank you very much for your question, Senator Joseph. I'm sorry. Go ahead.
You want to weigh in?
Yes.
Yes.
First and foremost, thank you for your question once again. The tow operators are our partners in law enforcement. They provide an essential service to this community, and they assist us for the most part. In absence of our own towing capability to store vehicles, based on this legislation, we'll be able to do that. They have been very good partners. And as business folks and the cost of doing business, I find that they act also as a deterrent for folks to register the vehicles. So it's not just the fine, the updated fines, but the fact that you know if your vehicle is not registered and the police officer have to remove that unregistered or uninsured vehicle from the roadway, the cost is a deterrent for you not to get. It's in your best interest not to get towed. And so we well, at least I know what we do in St. Croix. We help support the tow company because some folks think that they can go and make threats to the tow company. It is not their responsibility to register your car. It's their responsibility, once called upon by the police department or 911, actually, to tow the vehicle so that someone else does not pay a greater price for an unregistered or an uninsured vehicle being on the public road. And so I empathize with folks who feel that the towing business may charge exorbitant rates. I don't know what that exorbitant is. However, I can tell you this much. When someone gets into a crash and it's your friend or your family who has been a victim of someone hitting their car and you can't recover the cost, then you look at the police department to say, why didn't you remove that car from the roadway? So I don't see it. I don't see much issues with the towing company and what they have to offer. I see them as our partners. So thank you very much for the time.
Thank you so much. Mr. Chairman, I know I went over my time, but I do have a follow-up question, if you would be so kind to allow me.
Yes, continue.
Thank you so kindly, Mr. Chairman. You're very generous. You see, I do have that issue because, you know, we want to make our people lawful and abiding, but if they have been able to say, okay, I made a violation, but I want to now make good, we shouldn't put it so much of a hardship for them to become good. Everybody deserves a little bit of mercy. So I was wondering if it would be beneficial, and I hate to even say it, regarding the private companies, if we should have something that you guys could have it standardized, because in the absence of your empowerment, that is the reason why they are in business, you know, and they being able to store these vehicles. And I believe that's why the author of this legislation is doing this. So because it is coming a major issue regarding our people when they are caught, the vehicles is not registered, they get in an accident, etc. Is becoming a bit of a hardship for them. So is that something you could standardize or have conversation with your towing companies in the interim before your empowerment is put in place? So they have a standardized cost. Commissioner.
Oh, that question's to me. My apologies, Senator. Yes, Senator, I do agree. I will say that, again, while there may be some level of discrepancy in either district, for us, we need to we realize we have knowledge that we have to standardize the way these things are done. We can't have different towing companies charging different prices. It leads to convolution, it leads to problems when it comes to the citizens. We need to be fair, and I agree with you 150%. We have to be fair when we deal with the citizens. And what we've seen is we do have some record services that are subject to price gouging, preferential treatment, as I mentioned in my testimony. We've had situations where there's been vandalism when it comes to these vehicles when they're parked at some of these lots. We feel that as a police department, if we are citing your vehicle and that vehicle is to be towed, it is our responsibility to secure your property until you can retrieve your property. We should not be leaving that up to any third-party individuals to do that. I think it's the responsibility of us as a government, as a department, to ensure that we return your property to you in the same mint condition that that we impounded it at. I think it's the right thing to do. It's a fair way to treat those in our community, and not be putting our citizens in a position where one record service may tow them for $50 today, and then tonight the next one, tomorrow the next record company tow them for $250. It should be a standardized price. It should be a safe location where they themselves know their vehicle is kept in mint condition, the same condition they turned it over to us or we took it from them. I think it's a fair thing to do. We need to treat our community with fairness when we deal with them, and that is a road that we're taking, and that's why we support this bill.
Thank you so much, and I support this bill as well, but I do want to look at that standardized portion because it's not right for the people. Thank you so kindly, Mr. Chairman, for your leniency.
Your point of information is you recognize Senator Lewis.
Morning again, Commissioner. Real quick, I think I heard you earlier, and it's in your testimony. If I am not mistaken, currently you do have 2 impound lots.
We have 2 spaces identified, yes.
Great. And along those lines, I know the VIPD is always ready for everything. What about equipment?
We have records. We actually have records, without giving you that exact number in this platform.
The thing, tell the people what you
We have record services. We have records that we utilize to do those things. So we can.
You have flatbed?
Say again, we have we have flatbed and we have short pull, yes.
Thank you.
We can ensure that the general public vehicles are towed in a proper manner.
I think if I'm not mistaken, you submitted some pictures?
I did.
Media, could you put up the pictures of the equipment? See here. And you keeping quiet. Look. The next one. Good. So we ready?
We're ready.
Good. We have operators?
We have operators.
And staff?
And staff. We're ready to go.
Good. Thank you.
Both districts.
All right.
Media, could you put back up those? Media, could
Point
you?
of information.
No, hold on.
Hold on a second, Senator Joseph. Media, could you put back up the images so the commissioner could actually explain each of the records that was up, the equipment?
Okay, so that's a flatbed. That's one of the flatbed records. That record has the capability to tow up to 2 vehicles at the same time, one on the bed and one in the pull at the rear.
St. Croix or St. Thomas?
Both districts.
Wonderful.
And this is a short pull. As you can see, it also has what we call a dolly that we can ensure that the vehicle, if we need to lift the vehicle off the ground itself, we can do just that.
In both districts, we have the same equipment?
Yes.
Wonderful.
No, but newly bought this year.
Wonderful. Point. Senator Joseph, you recognize?
Thank you so much, Senator Joseph and Mr. Chairman. I just wanted to ask, these records are used primarily for criminal cases, or is it just all traffic violations? Because then I'm wondering why you're using the private record company now to still use their services as well as for impoundment.
So, Senator, we recently received those records and needed to ensure that we had the operators in place as well. Those records will be used for pretty much every touring type situation that we encounter, whether it's criminal, a case involved a vehicle that needs to be towed for any criminal activity, as a result of any criminal type situation, or relative to traffic having to impound a vehicle for whatever reason.
Thank you.
Senator Giddens, you're recognized for your 4 minutes.
Thank you, Mr. Chair. Let me see if I could do this in 4 minutes. First off, I thank the Senate Secretary for stressing the education while enforcing. The commissioner spoke mildly to, and I quote him as saying, "Just give me my ticket and let me go." He put it in a nice way, because certainly that's not the way it's being said. He also made a good point that guns don't walk, they're transported. And we keep saying that, and that's why we have to increase our enforcement initiatives. Now, as we increase the road safety, adjusting the fines simply serve as a deterrent for dangerous driving behavior, encouraging drivers to follow the law and prioritize safety on our roadways. And while we're promoting responsible driving, we must also emphasize the importance of adhering to the traffic regulations. As I look at it, from a fairness and deterrence standpoint, adjusting or updating fines to match the security of violations in the severity, rather, of violations ensures that those breaking the laws face appropriate consequences. And, I'm trying to go here based on just my notes because I know we have 4 minutes. But all the law enforcement officers as well play a crucial role. So for enforcement to be effective, officers must in fact be diligent with issuing citations and making sure that violations are swiftly addressed and not turn a blind eye or just simply allow people to slide. And again, public awareness and education is also key. So our Office of Highway Safety and the Traffic Investigation Bureau should be seen and heard. Both chiefs of police, Chief Hodge and Chief Cornelius, came in the department at a time when we had, I would say, in a good name of a pit bull as Lieutenant Melbourne Clark, who you could always hear on the radio and see on television speaking and promoting traffic safety and enforcement. So we have to have all our law enforcement officers, not just the Virgin Islands Police Department officers, but all law enforcement officers doing their part, as they will also be part of this initiative. And in closing, I want to express my sincere gratitude to each of you testifiers, colleagues, and even those of you watching and listening to this proceedings for considering and supporting this bill number 36, that's 0036, a measure to repeal and reenact a portion of Title 20 of the Virgin Islands Code by increasing outdated and antiquated traffic fines and establishing the police impound lot. Your backing will be instrumental in ensuring that our roadways are safer and that law enforcement has the tools to maintain order and protect the public. Let me also take a moment to stress that effective enforcement of these updated traffic fines is essential to the success of this legislation. Law enforcement agencies must remain vigilant in their efforts, and the attention to detail for our justice, attention to detail from our justice and judicial systems will be critical in ensuring that this law is implemented properly and equitably. So while we're talking or heard that fines are not being paid, this is exactly where our judicial system comes into play. Together, we can surely make a significant difference in the safety and well-being of our communities. And I just want to thank you all again for your attention, commitment, and service and support. So again, thank you for your service to the Virgin Islands Police Department and all law enforcement entities out there. Thank you.
Point of information.
You're recognized for your point of information.
Thank you, Mr. Chair. I stepped out for a moment, so I wasn't certain if the Attorney General mentioned in regards to the reckless driving or negligent driving. Was that addressed?
Yes, I was asked about that. Thank you. And I need to take a look back at it, and I promise to get back with a response.
Okay.
Yes.
Okay, thank you.
I don't want to make a, I don't want to make a guess.
Point of information.
Senator Gittins, you're recognized. You recognize.
Thank you. Again, this bill is to update the traffic fee schedule that we currently have as we go along. If there are any other additional adjustments to be made, the police commissioner is aware that he can work with my office or any senator to make any additional amendments, adjustments as needed as we go forward. But today, the measures to update the overall Title 20 of the Virgin Islands Code, specifically to the traffic fines and the establishment of the impound lot. So to answer his question with regards to negligent driving versus reckless driving, that will be addressed.
Thank you, Senator Giddens. Any other senator have any point of information? Senator Lewis.
Thank you, Mr. Chairman. Commissioner, I'd like to ask your commander in St. Thomas, Mr. Sergeant Libaba, a question, if I may. As we're on the eve of Carnival in St. Thomas, what is the process if your vehicle gets towed in St. Thomas this Carnival? Sergeant Libaba?
Sergeant Joycelyn Libab, Traffic Investigation, St. Thomas and John Juan Island. This Carnival, once your vehicle is towed, it's going to be towed by the police vehicle and it's going to be impounded. We have an open lot in the hospital ground area where the old human services parking lot used to be. Your vehicle is going to be stored there. And once you recognize that your vehicle is not at the place it is, you go to the front desk, they'll let you know that your vehicle was towed, and you're going to pay your fee at the police station for your vehicle, and you're going to come to the old human services parking lot where you will retrieve your vehicle.
Thank you. And that lot would be fully secured, as well as you talked about, Commissioner?
Lighted, manned, and protected, yes.
Thank you very much.
Point of information.
Senator DeGraff, you recognize?
Yeah, thank you, Mr. Chair. In regards to the same line of questioning, what forms of payment would be allowed when accepted when someone goes to retrieve their vehicle?
The cashier for the police department, by the records department, they'll be using cash or credit cards, no checks.
Okay, so PayPal and those different forms of
cash
payment
or credit card.
Only?
Only.
Okay, I just wanted to make sure. Thank you for the time, Mr. Chair.
Point of information.
PayPal and Zelle and all kind of things.
Point of information.
Senator Johnson, you recognize for your motion.
Mr. Chair, I move amendment number 36-337 to bill number 360036. Bill number 360036 is amended in section 3, subsection G, paragraph 1, by striking 65 and inserting $150.
Second.
Second. Amendment number 36337 has been properly moved by Senator Johnson. Second by...
Point of order, Mr. Chair. We point of order. In regards to the amendments, we're going to the vote?
Yes.
No. Oh, okay, I didn't hear that over here.
Yes.
Maybe that's why.
Yes.
Okay, so when you finish, I'll have an amendment. All right.
Second by Senator Avery Lewis. Having no objections, so ordered.
Amendment.
You recognize Senator DeGraff.
Yeah, thank you. I move amendment number 36-342 to bill number 36-0036. Bill offered by Senator Kenneth Gittins. Bill number 36-0036 is amended in section 4, subsection A, by striking the existing language in paragraph 1 and inserting the following. $3 for each paid traffic citation will be transferred to the Superior Court of the Virgin Islands, with $1 to be used for administrative purposes and $2 to be used for funding the Rising Star Steel Orchestra. I so move.
Second.
Amendment number 36342 has been properly moved by Senator DeGraff, second by Senator Johnson. Hearing no objection, so ordered. Do I hear a motion?
Motion. Motion.
Senator,
Motion.
I hear Senator Gittins, you're recognized for your motion.
Thank you, Mr. Chair. Mr. Chair and colleagues, I move that Bill number 36-0036, an amendment repealing and reenacting Title 20 Virgin Islands Code, Part 2, Chapter 43, Section 512, increasing penalties for traffic violations, establishing a Virgin Islands Police Department impound lot, and for other related purposes, as amended, be voted upon favorably here in this committee and be forwarded to the Rules and Judiciary Committee for further vetting and consideration.
Second.
I so move.
Roll call.
So move.
Second.
Roll call on Bill 30.
No. Second, right.
Oh, I heard a
Motion made and
I heard a motion has been made by Senator Gittins, second by Senator Avery Lewis. May I get a roll call on Bill number 36-0036?
Senator Angel Bolkes Jr.,
As amended.
Senator Bolkes, was that a yea or a nay? Yea?
Yeah.
Senator Bolkes, yea. Senator Dwayne M. DeGraff,
yes.
Senator DeGraff, yea. Senator Ray Fonseca, Senator Fonseca, absent. Senator Kenneth L. Gittins,
Yes.
Senator Gittins, yea. Senator Franklin D. Johnson,
Yes.
Senator Johnson, yea. Senator Avery L. Lewis,
Yeah.
Senator Lewis, yea. Senator Clifford A. Joseph,
Yay.
Senator Joseph, yea. Mr. Chair, you have 6 yea, 1 absent.
Bill number 36-0036, an act repealing and reenacting Title 20, Virgin Islands Code, Part 2, Chapter 43, Section 512, increasing penalties for traffic violation, establishing a Virgin Island Police Department impoundment lot, and for other related purposes as amended, approved by the Committee on Homeland Security and Public Safety, and will be forwarded to the Committee on Rules and Judiciary for further consideration. I so move.
Has been approved.
Has been approved.
The gavel again.
Will stand in the Committee on Homeland Security, Justice, and Public Safety stands in recess for 2 minutes. The Committee on Homeland Security and Justice and Public Safety is back on record. Colleagues, at the discretion of the chair, we will hear Bill number 36005 next. The sponsor of the bill in Block 2 had to attend a matter. We will continue with the meeting and adjust accordingly. Madam Clerk, please call up the next bill.
Bill number 36-0005, an act amending Title 16, Virgin Islands Code, Chapter 2, Section 99, establishing a mandatory minimum bail amount in domestic violence cases, sponsored by Senator Angel L. Bocas, Jr. Invited testifiers, Honorable Gordon Ray, Esquire, VI Attorney General, VI Department of Justice, Honorable Mario M. Brooks, Commissioner, VI Police Department, Dr. Clemma Lewis, Executive Director, Women's Coalition of St. Croix, Ms. Anya Stewart, Executive Director, Family Resource Center. Mr. Chair, that ends this block of the agenda.
At this time, thank you. And at this time, we're going to recognize Commissioner Brooks for a few minutes.
Thank you, Senator. Thank you to the Honorable Chair, to the public of the Virgin Islands under the sound of my voice. We did not submit a testimony relative to this specific measure. However, we will be supporting this measure in writing shortly to a letter to the chair. I'd like to also take this opportunity to recognize Police Chief Deborah Hodge as the first police chief in the St. Thomas St. John District at the Virgin Islands Police Department. I'd be remiss if I did not also recognize Deputy Chief Naomi Joseph in the St. Croix District as the Deputy Chief for this district, the first Deputy Chief in this district as well. It is these very remarkable individuals, and I use that term very loosely, signify exactly what we look for in leaders in the police department. Above reproach, determined, fair, firm, and I am very proud to have them a part of the membership team here in the Virgin Islands Police Department. I want to take this opportunity to again thank Chief Hodge for her service over the years, and I look forward for excellent things from this team moving forward.
Thank you, Commissioner Brooks, and I too would commend you and your decision, and I support all the women in blue, regardless of where you at. I'm supporting your supervisors, the newcomers. Women are a very essential part of our workforce.
Yes.
In any job. So we take time out, and I'm glad that you took the time out to recognize the two individuals that you actually are going to be leaning on the most right now, because that's what we do.
Yes.
We lean and they pick us up.
Thank you. That's on the operational side. Thank you. And I also neglected to acknowledge Deputy Commissioner Carolyn Watley, who's the lead in our support services. So again, another powerful female in our ranks, taking the helm and helping me to lead this department in a positive light. So I'm very appreciative of all of these very strong individuals in this department. Thank you again for the opportunity, and I ask to be excused.
And thank you. Well, good afternoon, testifiers. Good afternoon, testifiers. Kindly state your name and title for the record. I will be starting with Dr. Lewis. Could you recognize the mic of Dr. Lewis, please?
Point of order, point of order. Point of order, Mr. Chairman. Point of order, and point of information, rather. Mr. Chairman, we have to have the proponent of the measure speak first, and then we go to the testifiers to introduce the measure.
I'm only putting the testifiers on the record. They're not testifying.
just making sure that we are following that, because it's normally that. Thank you so much before you introduce the testifiers.
Thank you. Go ahead.
Is it on? Okay. Good afternoon, and my name is Dr. Clement S. Lewis from the Women's Coalition of St. Croix.
Could you recognize the mic of Mrs. Stadman?
Good afternoon, Julie Smith Todman from the Office of the Territorial Public Defender.
Good afternoon. Gordon Ray, Attorney General of the U.S. Virgin Islands.
St. Thomas.
Good afternoon. Anya Stewart, Family Resource Center. Good afternoon. Desiree Ritter Lambertus, Virgin Islands Police Department, Victim Witness Advocate.
Good afternoon, Deborah Hodge, Acting Chief of Police, St. Thomas, St. John, Water Island.
Good afternoon, Rael Donastor, Acting Deputy Chief of Police, St. Thomas District.
Thank you. Who speaks to this bill?
I do, Mr. Chair.
Senator Balkers, you're recognized.
Thank you, Mr. Chair. Greetings, Mr. Chair. Greetings, colleagues. Greetings to the people of the Virgin Islands. Today, I am proud to reintroduce a refined version of legislation previously presented as Bill number 35-0399. Now before you as Bill number 36-0005 with its companion amendment. This bill amends Title 16, Chapter 2, Section 99 of the Virgin Islands Code to establish a more structured and constitutionally sound approach to bail setting in domestic violence cases. Let us be clear, domestic violence remains a persistent crisis in our territory. Victims must be protected. At the same time, our laws must preserve fairness, due process, and judicial discretion. That balance is what this bill now seeks to achieve with an approved amendment from the VIPD and the Department of Justice. In its prior form, the legislation was passed in the last legislative session of the 35th Legislature of the Virgin Islands, but then vetoed by the governor, who raised concerns about fairness, equal protection, and the burdens of indigence. In response, and in direct collaboration with the Department of Justice and the Virgin Islands Police Department, I will introduce the amendment that addresses every issue raised. Specifically, Bill number 36-0005 now, through its amendment, eliminates mandatory minimum bail amounts and instead requires courts to assess the defendant's actual risk to the victim and the community. It also allows for full secure bail only when there is a clear and convincing evidence of danger or flight risk, thus restoring and respecting judicial discretion. It also empowers the court to consider non-monetary release conditions such as electronic monitoring, house arrest, or mandatory check-ins when financial hardship is demonstrated. It also requires courts to factor in risk assessments, victim input, and law enforcement recommendations before making bail decisions. And for the first time, the bill provides access to court-approved domestic violence intervention programs for all defendants, regardless of their financial status, ensuring we are not only responding to violence, but working to interrupt it and prevent it. Colleagues, this legislation does not punish poverty. It does not remove judicial authority. What it does is prioritizes victim safety, promotes accountability, and introduces a system of informed, balanced pretrial decision-making. I submit to you Bill number 36-0005 as a step forward toward justice that is fair, protective, and principled. Colleagues, I ask for your consideration. Thank you, Mr. Chair.
Thank you. Well, colleagues, not colleagues, testifiers, we will start with, we'll go to St. Thomas and we'll try and, since Commissioner Brooks set the standard for, we're putting the ladies out front today. So, Miss Anya Stewart, you're recognized for your testimony.
Good day to the distinguished members of the 36th Legislature, dedicated supporting staff, the attentive listening and viewing audiences. My name is Anya Stewart. I have the honor of serving as the Executive Director for the Family Resource Center, a private nonprofit organization committed to assisting victims of domestic violence, sexual assault, and other violent crimes in the District of St. Thomas, St. John's, and Water Island. Operating 24/7 with the support of our staff and trained volunteers, our agency is steadfast in its mission. I deeply appreciate this opportunity to address you today and share insights into the challenges faced by crime victims in our community, as well as the critical role we play in responding to their needs. I am here today to voice strong support for Bill 36-005, which proposes essential amendments to Title 16 of the Virgin Islands Code by establishing a mandatory bail amount in domestic violence cases and introducing critical measures to safeguard victims. This bill marks a pivotal step in strengthening protections for survivors of such crimes within our community. Domestic violence deeply impacts individuals, families, and the broader community. Survivors not only face physical harm, but also emotional, psychological, and economic trauma. Ensuring their safety while holding offenders accountable is a responsibility that cannot be overstated. This bill addresses these needs in several key ways. First, setting a mandatory bail amount ensures consistency and fairness in how domestic violence cases are handled. Moreover, the provision to prioritize a higher bail amount where applicable underscores the serious nature of these offenses and strengthens deterrence. This approach sends a clear message: the safety of victims and accountability for offenders are paramount. The clause requiring the immediate revocation of bail and remand to custody if a defendant contacts the victim post-release is vital. Such contact often results in further trauma, intimidation, and danger for victims, undermining their ability to heal and regain a sense of security. This provision emphasizes the responsibility of the judicial system to protect victims throughout the legal process by placing the burden on the defendants to demonstrate they are no longer a danger to the victim. The bill prioritizes the survivor's safety and well-being. The broader implications of this bill extends beyond individual cases. Implementing these measures fosters a culture of accountability and respect for victims, encouraging more survivors to come forward knowing their safety will be prioritized. It strengthens community trust in the justice system, signaling that domestic violence will not be tolerated and that victims will be supported at every step. Additionally, the clause requiring immediate remand and bail revocation if the defendant contacts the victim after release strengthens organizations like Family Resource Center's ability to protect our clients. This provision empowers Family Resource Center, Inc. to work more effectively with law enforcement and judiciary to address potential threats, ensuring victims can heal in a safe environment without fear or harassment or retaliation. Overall, the bill's measure would directly support the goals of victim service organizations by creating a safer and more secure framework for survivors, allowing them to focus on recovery and rebuilding their lives. This enhanced safety also encourages more victims to seek help, knowing that their well-being is prioritized and legally protected. Domestic violence has ripple effects impacting children, families, and even communities' stability. Supporting survivors not only addresses their immediate needs, but also contributes to breaking the cycle of violence. By passing Bill 36-005, This legislature can lead the way in making the Virgin Islands a safer and more supportive place for survivors of domestic violence. Organizations like Family Resource Center, Inc., which provides critical support services to victims and survivors of domestic violence, would greatly benefit from the provisions in Bill 46-005. FRC offers free services such as counseling, advocacy, safe housing, and crisis intervention. However, a major challenge that FRC faces is ensuring the ongoing safety of victims after offenders are released from custody. The mandatory bail amount outlined in Bill 46-005 would provide Family Resource Center, Inc. with increased confidence that offenders are held accountable and not quickly released back into the community without proper consideration for the safety of victims and, in many cases, their children. The measure reduces the likelihood of reoffending or further intimidation, offering survivors a strong sense of security as they access support services through our organizations. In conclusion, I strongly urge you to vote in favor of this crucial legislation. It represents a significant advancement in victim protection and community safety, reflecting our collective commitment to justice and compassion. Thank you for the opportunity to testify and for your dedication to this important issue. And on another note, I want to say congratulations to Chief Deborah Hodge. I know that you are going to do an awesome job. Welcome.
Thank you for your testimony. Dr. Clemmer Lewis, you're next.
Good afternoon. Honorable Clifford Joseph, Sr., Chairman of the Committee on Homeland Security and Justice, Honorable Ray Fonseca, Vice Chair, and other honorable senators of this committee, Senator Avery Lewis, Anhel L. Bogus Jr., Dwayne D. Graff, and Franklin D. Johnson. Other committee members and other senators present, as well as testifiers, listeners, and visual audience. My name is Dr. Clemmer S. Lewis. I am the Executive Director of the Women's Coalition of St. Croix. I would like to make a couple of acknowledgments first. I would like to let the chairman know that with me is Miss Aaliyah Joseph, a young woman in the audience. That is my court advocate. So she's in training to take over. Her name is Aaliyah Joseph, and she's the one that's in court all the time. Also, I want to acknowledge that April is Child Abuse Prevention Month. That's why I wear blue. And it's also Sexual Assault Awareness Month. So, Chairman, I brought you blue and teal ribbons that you could share with the senatorial staff for the month, because this is a big month for us. This is protecting children and survivors of sexual assault. So I'll continue after that. So I'm here to testify on Bill number 36-005, an act amending Title 16 of the VI Code, Chapter 2, Section 99, establishing a mandatory minimum bail amount in domestic violence cases. I want to take this opportunity to thank Honorable Senator Anhel Bogus Jr. for realizing the importance of domestic violence in our community and how important it is to keep families safe. I've been working in the field of domestic violence for over 40 years on the island of St. Croix. Actually, it was the Women's Coalition that spearheaded the first domestic violence council in the territory. It was this same group why there is now a domestic violence law passed, and it is recognized in other jurisdictions as the state of the law legislation, believe it or not. Domestic violence is on the rise in the Virgin Islands, and many abusers are becoming more dangerous. And I do mean more dangerous. I have personally been at the police station when several abusers were released on bail, and some of the reasons why they were able to get out right while myself and the victim was present. One, they had the $100 to get out. Two, a call was made to a judge, a lawyer, or a person in authority, and they were released on their own recognizance, which at that point put myself and the victim at jeopardy because we all at the police station at the same time. And then, of course, the perpetrator walked out laughing because he just got released after she's sitting up there with her mouth busted, her head busted, and she bleeding. This put victims in harm's way. The Women's Coalition then have to provide emergency shelter, food, clothing, and sometimes for safety of the victims, we have to buy airline tickets to get them off island for safety purpose. And that's happening more often than it is not. Sometimes the abuser re-victimizes the victim once they're released, and we can't get the criminal justice system to enforce the bail conditions or the violation of restraining orders. There have even been incidents where the police have called me and asked me to help them speak out on why certain perpetrators were released publicly. Furthermore, the criminal justice system, and I heard it earlier today, always using the term, abusers deserve fair and equal protection. I don't have a problem with that, but what about the victims? They don't deserve justice and equal protection as well? It seems like our system only look on the other side. We need to connect the dots in this community. Domestic violence is, I want people to hear this clearly, intergenerational violence from one generation to the next, and I have worked with families of 4 generations and seen it in every generation. It is now leaving our homes, as we all know in West where I live, and it's spilling in the street. Yes, we must hold the abusers accountable, help families, and try to make our families whole again because we're losing our family structure. The Women's Coalition is in support of this bill, Bill 36005, an act amending the VI Code, Section 299, establishing a mandatory minimum bail in domestic violence cases because too many people are walking out and continuing to hurt people. We made a few suggestions. I hope that's considered. Number one, when the defendant, before a defendant is released, the abuser or perpetrator, it is our hope that the victim testimony is taken into consideration, and it's not always taken into consideration. The nature of the act, because some is more violent than others, and the severity of the crime, what impact it had on the victim, the family, and the community. Subsection C, number one, we also want to say it's one thing to say that they need to enter a batterer's intervention program, but we need to add they have to complete the program. Because what a lot of batterers do, they will enroll and tell the court they're enrolling in, they drop out. So there need to be a certificate upon completion to say they finish it. This bill is very important to the community because it's about domestic violence on the rise. It's about saving our families. It's about protecting us. It's about protecting victims and the safety of families in our community that have been eroded. For some reason, our community has not been able to connect the dots of violence in the home is connected to violence in the street. Thank you, Senator Clifford Joseph, Chairman, for inviting me and giving me the opportunity to speak.
Thank you for your testimony, and thank you for the work that you do here in St. Croix, or the Virgin Islands as well. Next testifier will be Ms. Julie Smith Todman.
Thank you. Good afternoon, Honorable Senator Joseph, Sr. My name is Julie Smith Todman, and I am the Chief Territorial Public Defender for the Office of the Territorial Public Defender, which we call the OTPD. Let me thank you for allowing me to testify today. I was not originally on the list of testifiers, but I found out today while I was here that this matter was being brought to the floor today. Last year, when I found out about this bill, which was Bill 35-0399, I was not asked to testify about it, but I did write the proponent of the bill a letter, which you should have a copy. The bill has now been remarked as, or remade as Bill 36-0005, a bill mandating minimum cash bail provisions for domestic violence cases. And I wrote, Dear Honorable Senator Bolkes, on behalf of the Office of the Territorial Public Defender, OTPD, I write to strongly oppose Bill number 36-0005, which seeks to amend the territory's minimum bail provisions for domestic violence cases by requiring full cash bail. The individuals we represent will bear the brunt of this policy, facing prolonged pretrial incarceration, job loss, severe family disruption, and financial hardship. These consequences are disproportionate and unjust. Bill number 36-005 makes 100% bail mandatory, cash bail mandatory, and modifies minimum bail by inserting the phrase "not less than" before the specified bail amounts mentioned in 16 VIC section 99, subsection B1, B2, and B3. This means the court cannot exercise discretion and is forced to require the full 100% cash bail without the ability to take any other percentage into consideration. For example, a person need only allege that a defendant merely threatened to hit someone in order to force the judge to demand $5,000 in cash bail under 16 VIC section 99, subsection B, subsection 2. This applies to a person that has no prior convictions based on the mere allegations, and the police cannot exercise discretion to weed out nonsense complaints, even those where an alibi exists. The textual changes to subsection B are as follows and were highlighted in red. A person arrested for or charged with a crime that constitute domestic violence shall be admitted to bail as follows: not less than $1,000 with no 10% provision if the defendant has no prior conviction for domestic violence and the use or threatened use of a weapon was not involved, and there is no reason to believe that the crime for which the person was arrested resulted in substantial bodily harm. Or 2, not less than $5,000 and no 10% provision if the person has no previous conviction for domestic violence and the use or threatened use of a weapon was not involved, but there is reason to believe that the crime for which the person was arrested resulted in substantial bodily harm. Or 1 previous conviction for domestic violence and the use or threatened use of a weapon was not involved, and there is no reason to believe that the crime for which the person was arrested resulted in substantial bodily harm. Or 3, not less than $15,000 with no 10% provision if the person has no previous convictions for domestic violence, but the use or threatened use of a weapon was involved. Or B, 1 previous conviction for domestic violence, and there is reason to believe that the crime for which the defendant was arrested resulted in substantial bodily harm. Or C, 1 previous conviction for domestic violence, and the use or threatened use of a weapon was involved. Or D, the defendant has 2 or more convictions for domestic violence. That's 16 VIC subsection 9, hereinafter referred to as section 99. The law, as it presently stands, gives the court the discretion to reduce the bail, increase the bail, or leave the bail as is based on consideration of the provisions of Rule 5-1 of the Virgin Islands Rules of Criminal Procedure, which provides as follows. Subsection A, generally, subject to any specific statutory provisions, before conviction, all persons shall be bailable on conditions approved by the court. B, forms of bail or release conditions. Excessive bail shall not be required. the court shall impose the least restrictive of the following non-exhaustive range of conditions of release that will reasonably protect the community from risk of physical harm to others, to persons, assure the presence of the accused at trial, or assure the integrity of the judicial process, or if no single condition gives that assurance, shall impose any combination of the following conditions. 1, personal recognizance, which is pretrial release based upon the promise that the person will appear for trial or any proceeding in connection therewith as ordered by the court. This type of bail is used in place of a bail bond when the judge is satisfied that the defendant will appear without the need for a surety or other form of security. 2, unsecured bail bond. While the court finds unsecured personal recognizance inadequate, where the court finds unsecured personal recognizance inadequate, a bail bond in an amount for which the defendant is fully and personally liable upon failure to appear in court when ordered to do so, or upon breach of a material condition of release, but which is not secured by any deposit of or lien upon property. 3, travel and or residence restrictions. Where appropriate, placement of restrictions on the travel, association, or place of abode of the defendant during the period of release. 4, custody of designated person or organization. Where appropriate, placement of the defendant in the custody of a designated person or organization agreeing to supervise the defendant. 5, surety bond, where personal recognizance, an unsecured bond, and other conditions listed in 3 and 4 above are found inadequate, an undertaking by the defendant and sureties jointly or severally that the defendant shall appear for trial or any related proceedings as ordered, and upon failure to do so, defendant and the sureties shall pay the Virgin Islands government the amount set by the court as bail, or the property used to secure the defendant's release may be forfeited to the extent of the bail. Every surety except a corporate surety shall justify by affidavit and shall be required to describe in the affidavit the property by which the surety proposes to be justified and the encumbrances thereon, the number and amount of other recognizances and undertakings for bail entered into by the surety and remaining undischarged, and all of the surety's other liabilities. No recognizance shall be approved unless the surety thereon shall be qualified. Cash bail bond. 6, where none of the foregoing forms of bail is found adequate by the court to assure the presence of the defendant for trial, protect the community from risk of physical harm to persons, or assure the integrity of the judicial process, a sum of money designated in an order fixing bail and posted with the court by a defendant or by another person on defendant's behalf upon condition that such money will be forfeited if the defendant does not comply with the directions of the court requiring appearance at the criminal trial or related proceedings, and 2, does not otherwise render the defendant amenable to the orders and process of the court. 7, additional bail. As provided in 5 Virgin Islands Code section 3506, when proof is made to the judge that a person previously admitted to bail on a criminal charge is about to abscond and that bail is insufficient, the judge shall require such person to give better security or for default thereof cause the person to be committed, and an order for the person's arrest may be endorsed on the former commitment, or a bench warrant therefore may be issued setting forth the cause thereof. The bench warrant shall be issued by the clerk upon direction by the judge. 6, C, form and place of deposit. Unless otherwise ordered by the court, a person admitted to bail shall, together with any sureties, except a corporate surety, D, third-party custodian. In addition to the foregoing, the court may require a third-party custodian to further ensure compliance with the terms of the release and the appearance of the defendant in each of the foregoing instances. Each custodian must fully execute under oath the third-party custodian consent form before a defendant may be released. Authority to admit to bail. E. 1. In the absence of the judge, a person arrested and charged with a criminal offense which may be tried by the Superior Court may, before appearance before the judge, be admitted to bail by the clerk of the court, and in the absence of the judge and the clerk, may be admitted to bail by the chief of police or police official other than the arresting officer designated for such purposes by the judge. In any case, 2, in any case in which the judge may admit to bail, the judge may authorize the taking of the bail by the clerk or deputy clerk of the court or the chief of police or public official other than the arresting officer in the amount fixed by the judge. That's Virgin Islands Rule of Criminal Procedure, Rule 5-1. Bill number 36-0005 unjustly penalizes the poor. This is because, by definition, only people with less than $15,000 in the bank will ever be affected by this legislation. By setting a non-discretionary minimum floor on these bail amounts, Bill number 36-0005 removes crucial judicial discretion from the territory's judges as to the unique facts of each case. It must be emphasized that these are men and women are accused of crimes not convicted of them. The Virgin Islands Code already treats domestic violence allegations differently. Law enforcement is given broader powers, and alleged offenders are given less. The additional burden of Bill number 36-0005 unjustly falls upon the members of our community least able to afford it. This bill disproportionately harms the indigent accused, a group who are already vulnerable and often lack the resources or advocacy to voice their concerns. As such, the OTPD asks that the bill be reconsidered. As a prefatory matter, there's an ongoing Virgin Islands Code update which involves reviewing and updating the Virgin Islands Code in an organized and logical way. It is manifestly more appropriate to address complicated and pivotal matters involving incarceration in a programmatic instead of a piecemeal way. This is because utilizing piecemeal legislation when comprehensive legislation is on the horizon is ill-advised and problematic. The OTPD opposes the bill primarily because it removes judicial discretion in determining bail amounts and imposes a one-size-fits-all approach that fails to consider the unique circumstances of each case. This is particularly troubling for those who have been accused but not convicted of a crime. While the Virgin Islands Code already treats domestic violence cases with special consideration, Bill number 36-0005 goes further in burdening those least able to afford it. Several already existing aspects of local domestic violence laws are amplified by the proposed amendments. Broad definitions. The current domestic violence statute, section 91, has already created a situation where the definitions of domestic violence and victim are so broad that they can apply to individuals with only tenuous connections to the accused. The wide net cast by these definitions results in the law being applied in ways that may not always be fair or just. B, mandatory arrest. Domestic violence arrests under this law are mandatory, removing discretion from law enforcement officers. This mandates arrest whenever probable cause exists, even when the evidence may be weak or the situation less clear. Such a rigid approach undermines the fairness of the justice process, particularly for those who may not be guilty or whose involvement in the situation is unclear. C, lower probable cause standards. The current law allows for arrests based on minimal evidence, such as an uncorroborated written statement, which would likely not suffice in other criminal cases. This sets a lower standard for domestic violence cases and leads to arrests that may not be warranted. In addition to these concerns, which already exist in domestic violence cases, Section 99, as it would be revised by this bill, raises significant issues. 1, mandatory pretrial incarceration. The bill's provisions would increase the likelihood that poor defendants who cannot afford bail will remain incarcerated before their trial. This would exacerbate the already severe consequences of pretrial detention, including the loss of employment, housing, and family stability. It also disproportionately impacts those who lack financial resources. Constitutional concerns. 2, Section 99 has been ruled unconstitutional in the past. In 2009, the VI Superior Court in People of the Virgin Islands versus Phillips, 52 VI 130, VI Superior Court 2009, found that mandatory minimum bail provisions violated the principles of due process and equal protection. The U.S. Supreme Court has long held that wealth should not determine an individual's freedom, and this bill, by setting bail amounts based on an inability to pay, poses a constitutional risk. The VI Supreme Court did not review the Phillips decision. Further, other Superior Court judges are not bound by its reasoning, correct or not, because the decision of a single Superior Court judge is not binding precedent on other Superior Court judges. Phillips stands alone then in Virgin Islands law, absolving only Mr. Phillips as to the disparate impact of Section 99 on the indigent. 3, ambiguous legal definitions. The term substantial bodily harm is not clearly defined in the statute, which could lead to inconsistent application of the law. For instance, minor injuries such as scratch or contusion could be interpreted as substantial bodily harm, triggering mandatory bail even in cases where the injury is trivial. Application of bail schedule. The proposed legislation would add a new paragraph 4, which would state, if the underlying crime has a higher bail amount than the amount in Section B of this section, the higher bail amount shall apply. This is a confusing section. Bail amounts are set by case, not by offense. If a person is charged with multiple offenses, only one bail is given by the magistrate for that case, for the entire group of the offenses charged against the defendant. As such, it is confusing what the legislature means by referring to the higher bail amount. Should it be the case that the legislature is referring to the bail schedule which has been propounded by the Superior Court, OTPD strenuously opposes this suggestion. As the wording of the bail schedule already makes clear, when a person is charged with multiple offenses, the person shall post bail at the highest amount. Further, that bail schedule is literally constructed to cover the worst case scenario. It allows anyone to bail out of jail before seeing a judge if they have that amount of money. The same bail schedule applies to a first-time offender as a hardened murderer. To bind judicial officers by this schedule is the absolute opposite of what the Virgin Islands Supreme Court has indicated by propounding Rule 5-1 of the Virgin Islands Rules of Criminal Procedure. Further, bail schedules meant to be used by judges have been invalidated as unconstitutional unless it gives indigent defendants who could not satisfy the bond schedule a constitutionally permissible secondary option, a bail hearing at which the judge would consider all relevant factors when deciding conditions of release. 4, victim contact outreach. The current bill also seeks to add a provision where the defendant's bail is revoked and the defendant immediately remanded to custody if the defendant has any contact with the victim after his release from custody. Further, to be released, the defendant must demonstrate to the court that he is not a danger to the victim. As an initial matter, not all cases have a requirement that the defendant not contact the victim. Many times the defendant is going right back to living in the same house with the same people. In these cases, all the court is typically requiring is that the defendant have no unlawful contact by the defendant toward the victim. Further, revoking the posted bail seems an extreme measure that could be a great hardship not on the defendant, but on the defendant's family, who may have posted bail on his behalf. It is not unusual for a victim to post bail for a defendant. This measure hurts the victim for no good reason. Beyond these specific provisions, increasing bail amounts will likely worsen the broader issue of pretrial detention. Research shows that pretrial detention can lead to job loss, housing instability, and disrupted family lives. It also increases the likelihood of recidivism and has been linked to higher conviction rates despite not necessarily improving public safety. In contrast, jurisdictions such as Washington, D.C. have moved away from money bail systems, achieving high rates of court appearances and a reduction in pretrial detention, demonstrating that alternatives to money bail can be both effective and just. Because the OTPD is committed to advocating for reforms that prioritize fairness and due process, we strongly oppose Bill number 36-005 and advocate for reforms that prioritize fairness and due process. In conclusion, we urge you to reconsider Bill number 36-005 as expanding the use of 100% cash bail will not solve crime or promote public safety. Instead, it will place additional burdens on those least able to bear them. The OTPD stands firm in advocating for reforms that prioritize fairness and due process. We oppose Bill number 36-005, that is before the amendments, because it unjustly penalizes the indigent who are already vulnerable and lack the resources to navigate the system. And might I add that Susie Orman has always said that many families aren't even able to save $1,000. Thank you.
Thank you, Ms. Julie Smith Todman, Esquire. Thank you for your testimony. And Attorney General Ray.
Thank you, and good morning, honorable senators, legislative staff, and the listening and viewing audience. I am Attorney General Gordon Ray. It's my pleasure to appear before you today to address proposed bill number 36-0005. Thank you for including the Department of Justice in this very important discussion. Domestic violence continues to plague our community. Its effects do not end within the four walls of private homes. Children who witness domestic violence are statistically much more likely to turn toward violent solutions both in their families and within the community. It's critical that we, as a society, insist that those who commit violence against family and household members be held accountable and that potential offenders understand that the consequences of their actions may be severe. The Department of Justice served as the attorney for the people of the Virgin Islands and we recognize the need for increased bail in domestic violence cases. At present, in the Virgin Islands, bail in domestic violence cases is guided by 16 Virgin Islands Code Section 99B, which provides, quote, a person arrested for or charged with a crime that constitutes domestic violence shall be admitted to bail as follows. And then there's 3 different sections, depending on the severity. Number 1, $1,000 with no 10% if there's no prior domestic violence conviction and there's no threatened use of a weapon and there's no harm. Number 2, it's $5,000 with no 10% if there's a prior domestic violence conviction and there's no use or threatened use of a weapon or harm. And then there's a third level, which is a $15,000 no 10%. That generally is if there are 2 prior domestic violence convictions. The proposed amendment inserts not less than at the beginning of each numbered section and strikes the, quote, with no 10% proviso. Most importantly, it amends the domestic violence bail law by inserting language as paragraph number 4. That new language is, quote, if the underlying crime has a higher bail amount than the amount in subsection B of this section, the higher bail shall apply. The Office of the Attorney General supports this bill by adding language that strengthens the Virgin Islands bail law in domestic violence cases. Typically, in a domestic violence case, bail is set the morning after arrest by the magistrate judge. Upon information and belief, the magistrate judges do not, at present, consistently apply 16 Virgin Islands Code 99B 1 through 3, and in some instances, judges have deviated from the current law by assigning bail to domestic violence defendants upon lesser financial conditions than the law provides. The proposed language in this amendment should make the legislature's intent to set a minimum bail clear and bring an end to this practice. The additional proposed paragraph 4 makes the intent even more clear, as does striking the no 10% provisions. Further, under the current statute, it is common practice for judges to set bail in domestic violence cases at 10% plus 1. The statute lays out bail amounts and specifies that there shall be no 10% provision. So, for example, if bail under the statute should be set at $1,000, judges are routinely setting bail at $100, which is 10%, and $1. This has led to a situation in which both defendants and victims understand that offenders will be released with very little financial penalty. As one defendant was reported by the press to have said to his victim, "Go ahead and call the police. It's only $101. The proposed amendments will assist judges in setting bail in domestic violence cases that more accurately reflects our concern as a society for the safety of victims and the community. The proposed, quote, not less than, end quote, language makes the legislature's intent to set a minimum bail clear and provides ample authority for the judge to tailor bail to the facts and circumstances of the defendant. In other instances, judges have interpreted the current law as a limitation on the court's authority to set bail in domestic violence cases. This has led to dangerous defendants being assigned artificially low bail due to the domestic violence designation attached to the crimes they are charged with. For example, in an attempted murder case with no domestic violence designation, bail is generally set by the court at $100,000. If the same attempted murder was charged with the domestic violence designation, the current law in 16 Virgin Islands Code 99B 1 through 3 would apply, and the court may set the defendant's bail at $15,000. The proposed language for paragraph 4 makes it very clear that the legislator's intent is to prevent the application of the domestic violence bail amount to charges that are more serious and carry a higher bail amount. The proposed amendments clearly set a minimum bail and provide ample authority for the judge to tailor bail to the facts and circumstances of the case and the defendant while utilizing the word shall, so that judges know their obligation with regard to setting bail in domestic violence-related cases. One of the most important concerns in domestic violence cases is protecting the victim from further violence after a defendant has been charged, particularly once they have been released. This bail provides language that requires a revocation of the bail and release of any defendant who has contact with the victim in a domestic violence case after release, if the people can establish by a preponderance of the evidence that the defendant did indeed contact the victim. The provision further provides that, quote, to be released, the defendant must demonstrate to the court that he is not a danger to the victim, end quote. This provision is critical as it provides prosecutors with an important tool to protect victims in domestic violence cases. Sadly, defendants currently reach out to victims in the majority of domestic violence cases in the Virgin Islands and throughout the United States. We receive letters from victims asking that we, quote, drop the charges in approximately 70% of our domestic violence cases. We can, in most cases, continue forward with prosecution. As our criminal division chief in St. Croix often tells victims, I'm the bad guy. You can tell his family and his friends that you tried to drop the charges, but I wouldn't do it. Through the dedication of our attorneys and victims' advocates, we are able to seek a resolution in these cases, which includes treatment for offenders, while also supporting victims in seeking counseling and other support. The language in this amendment would underscore to both defendants and victims that no contact means no contact. This allows for a critical cooling off period during which legal resolution can be sought. I urge this esteemed body to pass Bill number 36-0005, which underscores our commitment as a community to protecting victims of domestic violence and holding offenders accountable. This concludes my remarks. Thank you for your time and attention today.
Thank you for your testimony. And the Committee on Homeland Security, Justice, and Public Safety stand in recess for 15 minutes. The Committee on Homeland Security, Justice, and Public Safety is back on record. Motion is recognized. Senator Fonseca, motion is recognized.
Thank you so kindly, Mr. Chair. Mr. Chair, I move Bill number 36-0036, an act repealing and Bill number 36-0024, an act amending Title 14, Virgin Islands Code, Chapter 85 by adding Section 1710, declaring a person incapable of consent to sexual relations while in the custody of police be held in the Committee on Homeland Security, Justice, and Public Safety for further review and consideration. I so move.
A motion to hold the bill has been recognized by this committee. Has been properly moved and seconded, moved by Senator Fonseca and second by Franklin Johnson. Hearing no objection, so move. So ordered.
Point of information.
Committee of Homeland. Point of information. Senator Bolkert, you're recognized.
Thank you, Mr. Chair. Mr. Chair, my point of information is to express the responses to the concerns of OTP. The amendment, which is 36-338, addresses most of the concerns of OTP. It restores judicial discretion. The amended language now states bail must be determined based on the defendant's risk to the victim and the community and fully secured where there is clear and convincing evidence of a threat to the victim or likelihood of flight. This allows courts to tailor bail decisions to specific circumstances to avoid a 100% blanket cash bail in all cases. It also addresses indigent defendants and alternatives. The amendment allows alternative non-monetary conditions, such as electronic monitoring, house arrest, or mandatory check-ins, where the defendant demonstrates financial hardship. This directly addresses the concern about unfair impact to the poor defendants. It also clarifies conditions for bail revocation. The original bill said bail is revoked upon a preponderance of the evidence of victim contact. The amendment changes this to a clear and convincing evidence standard and ties it to protective order violations, a more precise and legally sound trigger. The amendment also incorporates risk assessments. The court must now consider risk assessments, victim statements, and law enforcement recommendations, ensuring a more holistic review of each individual case. The amendment also expresses programmatic support and funding. It allows for the court-mandated domestic violence intervention programs, which is mandated, and also funding from the legislature for those programs. Also, the amendment also deals with the constitutional issues of due process concerns. The original concern is mandatory bail without individualized assessment violates due process. The amendment removes not less than and fully secured language and replaces it with, however, bail must be determined on the defendant's risk to the victim and the community and fully secured where the
point of order
and evidence of a threat to the victim or the likelihood of flight. This restores judicial discretion.
Excuse me, Senator Bolkers. We have a point.
Evaluation. Equal protection concerns.
Senator Bolkers.
It's a point of order.
Senator Bolkers. Senator Bolkers.
Defendants. The amendment.
Point of order, Senator. Point of order. There's a point of order on the floor. Yes. Senator Gittins, you recognize
the point of order is, I mean, this is becoming a testimony and not a clear point of information there. So are we allowing a separate testimony there? I mean, that information is for debate time. I mean, it's going in too deep.
Which, if I may ask, through the chair, what rule has been broken?
Okay, Senator Bolkes, you could wrap up because the information is clear on this end. Because we had a question, but it's cleared between the Attorney General office over here. So at this point, you could just go ahead and wrap up.
Thank you, Mr. Chair. Concerning the equal protection concerns, the original concern is that the flat cash bail unjustly penalizes indigent defendants, and the amendment fixes it by allowing the courts to consider alternative non-monetary conditions for the indigent population, such as electronic monitoring, house arrest, mandatory check-ins. The outstanding concerns is from the
Thank you,
OTP
Senator Bolkes. You're going to have your time. You're going to have your time. So, colleagues, at this time, we will allow 4 minutes to each individual. Starting with Senator Avery Lewis.
Thank you, Mr. Chairman. Good afternoon again, colleagues. Good afternoon, testifiers. Good afternoon to the listening and viewing audience. Ms. Tadman, how are you today?
Thank you.
Great. In the amendment as it is there in the amended form, does it answer any of your concerns you had earlier in your testimony?
Thank you, Senator Lewis, for your question. I received the amendment this afternoon, and the amendment addresses many of the things that I raised in my testimony. I wished I'd had this amendment prior to my testimony because it does seem to address all of the issues that I raised.
Okay, and you're comfortable with the amendment?
I'm comfortable with it, but you know, I think I do like to be Switzerland here at times. So it addresses my questions, it addresses my issues. But whether this gets passed or not, I'm going to be Switzerland.
Thank you. Attorney Gordon Ray.
Yes.
The proposed amendment includes a not less than minimum bail. Can you explain to me how this will ensure more consistent application of bail laws and how it may prevent judges from setting bail amounts lower than what is necessary for public safety?
All right. Well, with respect, if I just may say, the latest amendment that was proposed changes that, and I think does a good job of it. And so I have to agree with the Attorney Todman that the latest amendment takes care of a lot of issues that she raised that I think are valid issues to raise. And I think this latest amendment works. And so I am in favor of it. And I think that takes care of all the problems with respect to not less than language. And it also takes care of the problem of disparities in wealth. And it also lets the judge exercise discretion to weigh the risk of danger and that sort of thing. So, and likelihood of flight, of course. So I support this this latest amendment.
Thank you, Attorney Tadman. The bill includes a provision for automatic bail revocation if the defendant has any contact with the victim. In your experience, how could this provision be misapplied or led to unintended consequences for both the defendant and the victim?
Well, I don't think there's any automatic bail revocation. You still have to go before the judge, and the judge makes that decision. So although it may stay in there, what it will state is that you have to go before the judge, and the judge, because you have to present the facts to the court for the court to determine whether the bail should be revoked or not. And there are times that we've gone to court where the prosecutor is not able to bring forth the testimony that's required for that bail revocation. So you have to have the person to come and provide that testimony for the court to be informed and to make that decision.
Also, in your testimony, you emphasized the negative impact of the mandatory cash bail on indigent defendants. You're comfortable with the amendment now with that?
Yes, Senator, because it addresses those concerns.
Great. Just wanted it on the record. Thank you, Mr. Chairman.
Thank you, Senator Lewis. Senator Dwayne DeGraff, you're recognized for your 4 minutes. Okay. Senator Franklin Johnson, you're recognized for your 4 minutes.
Thank you very much, Mr. Chair. Good afternoon to all testifiers, colleagues, viewers, and listening audience. I want to direct the Attorney General. I don't know if you saw Ms. Todman testimony or you have a copy of it, but on page 7 of 8, there's 2 areas that I would like for you to address. The second one was constitutional concern, section 99. And I want to know if the amendment addresses this constitutional concern, because I'm always trying to be that balance to make sure that nobody is being taken advantage, especially with the constitutional right. So, have a copy of that section?
Yes, I do. I see the constitutional concerns section, and it seems to me that the latest amendment takes care of that, because it allows the judge to exercise discretion based on the facts of what happened, of the defendant and defendant's situation, and it doesn't require a judge to do any specific thing that would be prejudicial. And so I think that overcomes the constitutional issues.
And then the top part, right above that, mandatory pretrial incarceration.
Right. And obviously, this amendment does not have a mandatory incarceration anymore in the bill. So I think that takes care of it as well.
And my last question to Ms. Todman, are you satisfied with this amendment as far as you're concerned? Because some of the things that you raise my eyebrow to, and I don't have a problem in strengthening these laws, which I know need some strengthening. But at the same time, I don't want to be someone taking advantage of anybody by putting any laws or any bills in place that will be advantaging anyone from either side.
Senator, thank you for your question. And I want to thank Senator Bolkes for the amendments to this bill, because obviously what he has done, he saw my letter from last year, he saw the response from the governor, and he took those into consideration. And this amendment addresses the issues that I raised.
I have no further question. Thank you very much, Mr. Chair.
Thank you, Senator Johnson. Senator Gittins, you're recognized for your 4 minutes.
Thank you, Mr. Chair. Pertaining to this, I'll be very brief, because I'm still trying to decipher this whole bill and what we're trying to get at here. And while I want to protect all our citizens, we also need to protect those who find themselves on the opposite side of the law. And I don't wish to, in any way, form, or fashion, tie the hands of our judicial officers. As we discuss, I need to be clear that we wouldn't be tying their hands where they can't if the crime is much more serious than a DV situation, meaning a domestic violence case, that the judge's hands are tied from ensuring the presence of that defendant back at court by being able to increase the bill. And I say that meaning, just as an example, currently the law for under domestic violence is progressive, where it moves from 1,000 to 5,000 up to 15,000. So if an individual is arrested under the domestic violence, sorry, let me pull that back. If an individual is arrested for a regular assault first case, where he utilizes a machete and chops someone on the hand, that's an assault first. Just say the bail is $25,000. In the case of it being a domestic related incident, if one uses a machete and cut off someone's hand, it's an assault first. However, the assault first under the Domestic Violence Act may be $15,000. In this case, now the judges will be tied at that $15,000 because it's domestic violence related. So my suggestion would be to have that no less than clause where we don't tie the judicial officer's hand. Every case has its own merits, and the judges should have that leverage to determine what the bail should be. And again, colleagues, just a reminder for everyone, bail is not for punishment. Bail is simply to ensure the defendant's return to court. So we should not look at bail as a punishment, or punishment can come before an adjudication. So we have to be really careful in this, and I would just prefer to, on the side of caution, I would prefer to have further conversation with those who are directly responsible, and then coming back and addressing this. So at the appropriate time, I will make a decision on voting. I do support the overall, what is trying to be done, but I want to do this the correct way. Thank you, Mr. Chair.
Thank you, Senator Gittins. And next senator recognized for his 4 minutes will be Mr. Ray Fonseca. I recognize Senator Carla Joseph for your 4 minutes.
Thank you so kindly, Mr. Chairman, and I just want to say you're doing a really good job today in managing this, your inaugural meeting. I'm very proud of you, especially knowing that you carry my last name as well. And so I really want to commend the bill sponsor for bringing forward this very important piece of legislation that addresses increasing violent activities within our community. I just had the opportunity to speak with Ms. Anya Stewart from the Family Resource Center. And my question is to her, and as well as Ms. Clemma Lewis. Dr. Clemma Lewis, have me excused. Dr. Clemma Lewis, I hope she's still there, regarding what are we seeing as a landscape relative to what is happening with domestic violence issues within our territory? How is it looking? Are we seeing a decrease, or are we seeing an uptick in those type of incidents within our community? First, Ms. Stewart, kindly answer.
Good afternoon, I'm Anya Stewart, and yes, we have seen an increase. As of yesterday, while I was tallying my data, one social worker, we have 9 staff that deals with clients who walks in or they go to the schools, and one staff gave me her report and she saw 84 clients for the second quarter this year.
84?
And that's just one staff.
One social worker?
One social worker, our French bilingual social worker, because she see both English and French speaking clients. So she alone have 84. When I saw it, I was like, wow. And I have yet to tally the 8 remaining staff. So it has been increasing from Irma Maria to COVID-19, and now with the situation with our economy and everything that's happening, it is rising.
Wow, that's a startling number. Dr. Clement Lewis, are you there? Can you talk about what we're experiencing with our brothers and sisters in St. Croix?
Yes, Senator, and thank you for asking the question. Domestic violence is on the rise. It has become more violent, and I want to be clear, up until Monday morning at 4 a.m., I was at the police station with a woman whose jaw was broken. No one was arrested. And that's the norm here in the community. They don't get arrested, so they don't get bailed, and they don't have to go to jail because most of the time they're not arrested. So we're seeing the uptake. We're seeing more violence. They're going into homes. Nobody is doing anything. So our shelters are full. We're sending more people off island, Senator. Everyone, I have transitional housing and a shelter, and all of them is full because we have to provide the safety when nobody else in the community is. What we really need to understand when we talk about being fair and justice on both sides, children are caught in the middle. They are watching this and they're repeating the behavior out at school and in the streets. And yes, I'm concerned, and yes, I believe in this justice and fairness, but I do not believe it applies when it comes to victims and what happens to them. We seem to keep forgetting that piece.
I want to thank you for placing that on the record because I know the importance. I have had to work with families and women and children who were victims of domestic violence and having to place them in housing, emergency housing, even through the Virgin Islands Housing Authority before I even worked there. So I understand. I understand clearly the dynamics, and I know definitely Attorney General Gordon Ray does that, as well as our good attorney for the Public Defender's Office, Attorney Todman, realizes that. I know I would definitely be in support of this legislation. I really commend the bill sponsor for taking extra time to go at length to bring the amendment that would clarify some of the issues that were raised when the bill was vetoed in the 35th legislature. So, Mr. Chairman, I thank you so kindly for the time.
Thank you. I now will recognize Senator DeGraff.
Thank you, Mr. Chair. Good afternoon, colleagues. Good afternoon, testifiers, all of you listening and present. I voted for this bill last year. I voted for it again this year. Simple as that. I have 3 things written down. One, if you're going to do the crime, expect to pay the time. I was in the police for 26 years to take anything lightly. So if you're going to do the crime, expect to pay the crime, pay the time. Whether you're affluent, whether you're indigent, whether you're green, pink, or purple. Okay? I think we all adults should understand what it's about being an adult. That's number 1. Number 2, what about the victim? I've seen many, many victims here in the territory, not only in domestic violence cases, in many cases. What about the victim? We take it into consideration. Oh, he beat her up, but he don't got a job. He indigent, he ain't got no money. He can't speak English. Jail is for universal, for everyone. Whether you can speak English, whether you have a job, whether you don't have a job. Are there things that are unfair to individuals? Yes. I'm not for that. So don't get me wrong. And finally, Attorney General, when we use the standard of probable cause to arrest someone for domestic violence, any crime, Now, is it fair to use the standard of preponderance of evidence after that person has been released and the victim makes a complaint? Is it a fair trade-off, or should there also be the standard of preponderance, no, not preponderance, reasonable doubt or anything going forward? Probable cause.
Yeah, my sense would be, I presume you're talking about the issue of the contact with the victim after the person's been released. And so I think that should be, that person has not yet been found guilty beyond a reasonable doubt. And so it would make sense to me that the probable cause or preponderance of the evidence standard would be the appropriate one, not beyond a reasonable doubt at that stage.
No, I got that, but preponderance of evidence, more likely than not, it occurred.
Yes.
Probable cause caused that individual to be arrested in the beginning. They were arrested based on probable cause.
Yes.
Now, they're arrested, they've been given bail, they post their bail, they're out. Now we're going based on the standards of preponderance of evidence, where the victim or someone may have said, hey, they did X, Y, Z or ABC. More likely than not, would the standards have dropped in preponderance of evidence?
I think the preponderance of evidence means it's more likely than not, because that preponderance would mean that it's more evidence that it happened than that it didn't happen. And I'm comfortable with that standard.
Okay, good, good. I just wanted, because again, I voted for the bill, but now in question, I was just looking at probable cause. I always know to be a higher standard, so I just wanted to make sure. So I'm ready to vote. Thank you for the time, Mr. Chair.
Thank you.
Thank you, Senator DeGraff. I now recognize Senator Fonseca for his 4 minutes.
Thank you so kindly, Mr. Chair. I too must commend my colleague on sponsoring bill number 36-0005. It allows a little bit more leeway for the judges when determining the bail amounts, and it also makes it stiffer for the defendant to be released on bail. So that is good. However, you know, there's an underlying issue here of anger management, because a lot of the times these domestic violence issues are the results of anger management or mismanagement. And even after the case is solved, the couples are back together again, and, you know, few months or maybe even a year or so down the line, the same thing happens over and over again. So, you know, at the appropriate time, I want to make an amendment to this bill so that we include some anger management issues, and I would like to see the judges recommending, in addition to the sentence, anger management counseling, because anger management works, and the goal here is to prevent the domestic violence, because, you know, sometimes they're back together again, you know, and then the same thing happen, and then whoop, domestic violence and, you know, the issue. So let's work to help our community and resolve these domestic violence issues, because a lot of the times, you know, the couples are really in love with each other, you know, and things happen, you know, they could have been out drinking and stuff. You know, alcoholism is one of the things that causes a lot of violence, you know, and you see it all the time. So I'm going to, at the appropriate time, offer an amendment so that we can get specific anger management counseling into this bill. And I congratulate the bill sponsor. This is something that's very, very well needed. And I also congratulate both of the testifiers who gave testimony to the bill and strengthening the provisions, because, you know, you don't want to get in a domestic violence and then you're out on bail for $101. That's not fair to the system. The amount of time and effort the attorneys, the VI Attorney General spends, his staff, the courts, the VIPD, is so much time and effort, has been put into this issue. We can't have a defendant out on bail for $101. That's no penalty at all. So again, congratulations to the bill sponsor and Mr. Chair. Thank you so kindly. And I'd like to say you are conducting an extremely excellent first meeting. Thank you. Thank you for the time.
Thank you, Senator Fonseca. Now we'll recognize non-committee member, Mr. Senator Francis.
Thank you very much, Mr. Chair. Good afternoon to you, my colleagues. Good afternoon to the testifiers. Good afternoon to the people of the Virgin Islands. I'm not a member of this committee, and unfortunately, I wasn't able to hear some of the testimony as I attended an emergency meeting over at the hospital before here. But certainly, Bill number 36-05. This bill before us is one of concern to me. Obviously, we have made some inroads in respect to domestic violence cases, and we still have a ways to go. There is no excuse for abuse. Alcohol, weed, whatever. There's no excuse for abuse. So again, if we're talking about anger management, and that is part of the reforms or consideration, rehabilitation process, where we do have, at least in the St. Croix district, we do have the Men's Coalition that supports and assists in the anger management and working with the batterers to overcome this situation. I'll tell you that I've been a strong advocate, again, for domestic violence prevention over the years, certainly with Clemma Lewis and Mary Mingus for many, many years. We go way back and move meaningful legislation over the time. I issued Chief's Directive and Commissioner's General Orders, again, to ensure that we're protecting this community. We even worked sometime when I came into the legislature with Senator Positive Nelson, where we even expanded stalking as part of legislation to address this particular issue. Anything that will continue to protect the victims is something that I support. I know that a lot of times in domestic, well, all the time in domestic violence cases, there's no bill attached to it before your first appearance before the judge. And now I'm seeing that there's a requirement, or being made a requirement, for at least 100% cash bail mandatory. Mr. AG, you say you're in support of this legislation?
Yes, and with the amendment, the most recent one that was just presented, I think that takes care of the issues raised by Attorney Todman and still reaches a fair result.
You know, the judges usually scoff at mandatory minimums because they kind of tie their hand to this, right?
Right, and this amendment removes the mandatory language.
Very well. And Chief, how are you doing today? Please turn on the mic of the Chief, Public Defender. I saw in your testimony that you had some serious concern about this measure, and those have been met with the amendment as well?
Yes, they have been.
Okay, so you believe that setting a bill, even if the minimum was $15,000, will certainly meet the conditions?
Well, I believe that the amendment, which puts the discretion back in the judge's hands, addresses the concerns that I raised in my letter to Senator Bolkes, and Senator Bolkes took that into consideration in making the amendment when he says, however, bail must be determined based on the defendant's risk to the victim and the community and fully secured where there is clear and convincing evidence of a threat to the victim or likelihood of flight. So now the judge will have to have that testimony to make a decision regarding the bail, and there's no mandatory amount here in the amendment.
And in your situations or circumstances that you have had, a lot of time it'll be up to the police officers' testimony or presentation before the judge. They'll then determine, or if there is no rap sheet, will determine.
Time.
Mr. Chair, if I may just wrap up.
You may continue.
Will determine the conditions by which the individual should be released or consideration should be given for bail?
Yes, and sometimes we do have family members that come to act as third-party custodians, and the judges get to, the attorneys, the prosecutor and defense attorney and the judges get to question that third-party custodian who can tell who can tell the court whether this person is employed, whether this person is in school, how many children. So the court has all of the information to make an informed decision regarding what they believe the bail should be.
So would you also agree that Richmond Poorman batterers are not determined by status, and that in fact we have seen where individuals batter, despite of their social status or education status, they still batter, and how then will the judge be able to make a determination in terms of whether or not they should set bail? How do you believe that that determination will be made by the judge?
Well, the judge has to consider risk of flight, ties to the community, the criminal history of that person, and other factors that are listed in 5-1, Virgin Islands Rules of Criminal Procedure. And I think the judges try their very best to be fair when they make those decisions. However, sometimes we've seen where judges have set bail, very strict bails, even though we do have former public defenders who are now judges. We've seen cases where they've set bail of $25,000, $30,000. So I think the judges pay attention to the facts that are given to them. When they set bail. We may not agree with what the judges set, but we can respect that they have taken a good look at the factors that are presented to them, and they make the best decisions that they can with the information that's presented to them.
And I guess that's why it's so important that our presentation is made before the judge, to make sure that we have as much information as possible, provide the judges with as much information as possible so that they can make an informed and proper decision, because, again, outside of that, it could be catastrophic.
Yes.
Thank you very much, Mr. Chair, for the time. Again, I'm not a member of this committee, but I think that a discussion is certainly necessary and warranted. And I'll tell you that, as we have heard, we see that domestic violence continue to be on the rise as we speak right now, despite the tremendous amount of work that we have put forth to prevent this. And I could just continue to implore and encourage, those of the advocacy to continue to hold strong and do their part, again, to discourage domestic violence. Thank you very much, Mr. Chair, for the time.
Thank you, Senator. Thank you, Senator Francis. Senator Balkes, Jr., you're recognized for your 4 minutes.
Thank you, Mr. Chair. So I wanted to thank the Office of the Territorial Public Defender for her comments. This is a deliberative body, and it is healthy for us to dialogue and have discussion, pros and cons wise. And I appreciate her involvement and statements concerning the amendment, as the amendment restores judicial discretion. It allows non-monetary alternatives, raises legal standards for revoking, the bail, and integrates risk-based assessments, and provides programmatic support and ensures access to everyone, regardless of income. And I wanted to say that with the anger management, that also comes as part of the services that the intervention programs provide. And I must note that these intervention programs are free with these nonprofit organizations. So that's a plus for us, and we appreciate all of the work that they do every single day dealing with our victims in our society. And I want to say that this bill is not about locking people up. It's about protecting victims from repeated harm and breaking a cycle of violence. By including access to court-approved domestic violence intervention programs, we're actually offering a path forward for behavioral change and not just punishment. So the inclusion of the domestic violence intervention programs in the amendment, which is amendment number 36-338, which I plan to bring forward, reflects a shift toward a more balanced approach to justice, one that holds individuals accountable while offering meaningful opportunities for rehabilitation. And also by allowing the court to require participation in a certified intervention program and ensuring funding for the defendants, regardless of financial status. However, I may have to look at that a bit more closely, but it is something that we should all discuss because this is a very important issue that we're dealing with, and if we're not going to curtail it now, when? And you know, I know that the Office of the Territorial Public Defender made their statements and issues concerning the bill when it was in the form of Bill number 35-0399 in the previous legislature of the Virgin Islands, and I adhere to the call. I take these things very seriously. If there's anything that I can do to, as a legislator, that I can do to try to work with, regardless of institution or branch, with individuals who are considered to be the stakeholders, I'm going to do my part. And this is something that we've been working on. I've had discussions with the Attorney General from the inception, in addition to when the bill was vetoed. And I also want to thank him and his office for being able to collaborate with us and have discussions and provide insight and support as we continue to try to refine this bill into what you see before you today. In addition, I want to thank the Commissioner of the Virgin Islands Police Department, which also provided recommendations from their legal counsel division within the Virgin Islands Police Department concerning any concerns that they had specifically with the previous version of this bill, which all of those recommendations were adhered to include the Office of the Governor when it was vetoed, to include the Office of the Territorial Public Defender. So we have been on the ground working towards what you see before you today. And colleagues, I just ask for your consideration moving forward. Thank you for the time, Mr. Chair.
Thank you, Senator Balkers. Colleagues, we have exhausted all the time for this block. I would like to allow the testifiers to wrap up with 30 seconds. I will start with, I'll start with you, Dr. Lewis.
I would like to say thank you to Senator Bogus for bringing the bill forward because it needed to be brought forward. I will continue as long as I'm breathing to fight for victims. As long as this system gonna be pro-criminals and abusers, we still need the other side. We talk about balance, we really need to balance the system. Again, at 4 a.m. in the morning, I was with a young woman whose jaw was broken. Maybe if y'all saw some of them cases, y'all would understand where we're coming from. I do appreciate the fact, and I support the fact that everybody needs to get help because it's trauma and it's intergeneration. The victim needs to get services, the children need to get services, and the perpetrator need to get services. And one thing about the Virgin Islands, we have services for all three. It's just whether they accept them or not. Again, thank you. I hope you support this bill because we continue to fight for justice for victims because they are the injured party. Whether they rich, poor, come from families or whatever title, victims are victims. And I really need y'all to think about that when y'all considering legislation. Thank you.
Thank you. Ms. Anya Stewart, ED.
Good afternoon. Good afternoon again. I would really like to say that in the open, that we provide men-terminating violence counseling for men. Most of the time, the judges refer them to our agencies or somebody who knows someone who's going through trauma, they would refer them to us as well. So the same services they provide on St. Croix, we provide the services on St. Thomas as well. And I'm taking this opportunity to thank Senator Bolkers for amending this bill because we know it is well needed in our community because it's not only the women, men are being abused too, so it goes both ways. I know we're stressing on the women, but the men are being abused. I've seen it firsthand, and they need the help as well. So let's continue to work together, collaborate. We cannot do it without each other. We have to sit on the drawing board. We have to go back to the drawing board to make sure that all these things are put in place to help the victims that we serve in our community, because they are traumatized and their children are traumatized, and the perpetrators also need the assistance. We have to teach one, and then we have to teach all. Let's continue to work together to make the Virgin Islands great. Thank you.
Thank you. Attorney Todman.
Thank you, Senator Joseph, and thank you for the opportunity to be here today. And I want to thank Senator Bolkes for taking my comments from last year into consideration in proposing amendments to Bill 36-005. You know, although I represent the indigent in this community, please understand that I'm also a member of this community. And so today I'm here representing the OTPD, but we are aware that crimes occur, and so we still need to protect the victims in this community, but we also have to watch out for those of us who are, for those who are also indigent. We are all part of this great melting pot of the Virgin Islands. And thank you so much for your support.
Wrapping up, AG, Rhea.
Yes, thank you. And thank you for inviting me to examine these bills and to testify about them. And I particularly want to thank Senator Bolkes for the hard work that he's done on this really critical issue. And my sense is that the amendments that have been proposed keep the real strength in the bill. It's a bill that is to help people in distress, and at the same time it comports with the constitutional guarantees of due process. And it also reminds judges who are to use their discretion, quote, bail must be determined based on the defendant's risk to the victim and the community, and fully secured where there is clear and convincing evidence of a threat to the victim or likelihood of flight. So I think that makes the judge's task clear to the judge, that he's to do the thing that's right and fair, but don't forget, this is a case in which there's a victim. So I'm fully behind it.
Again, I'd like to thank all the testifiers, and the Committee on Homeland Security, Justice, and Public Safety stands in recess for 2 minutes. Committee on Homeland Security, Justice and Public Safety is back on the record. Do I hear a motion?
Motion, Mr. Chair.
Before I go on, before the motion continues, testifier, you are excused. And thank you for your testimony. Motion, continue. Senator Bolkers.
Thank you, Mr. Chair. Mr. Chair, I move amendment number 36-338, amendment to bill number 36-0005, offered by Senator Angel Bolkers Jr. Bill number 36-0005 is amended in the following instances. 1. In section 1, subsection A, parentheses 1, parentheses A, parentheses 1, comma, 2 and 3, by striking not less than and fully secured and inserting the following sentence after harm. However, bail must be determined based on the defendant's risk to the victim and the community and fully secured where there is clear and convincing evidence of a threat to the victim or likelihood of flight. 2. In subsection B, by striking if the defendant has any contact with the victim after release and the people can prove the defendant contacted the victim by a preponderance of the evidence, and inserting if the people can prove by clear and convincing evidence that the defendant contacted the victim in violation of a protective order, the defendant shall be remanded to custody and bail shall be reconsidered based on the severity of the violation. The court may consider alternative non-monetary conditions such as electronic monitoring, house arrest, or mandatory check-ins where the defendant demonstrates financial hardship, provided these measures sufficiently protect the victim. The court shall consider risk assessments, victim statements, and law enforcement recommendations when setting bail or release conditions to ensure protection of victims while upholding constitutional protections. 3. In subsection C, the following language is inserted at the end. The court may require the defendant to complete a domestic violence intervention program from a court-approved provider. The legislature shall appropriate funding to the judicial branch to ensure access to such programs for all defendants regardless of financial status. I so move.
Second.
Amendment number 36-338 has been properly moved by Senator Bolkers and second by Senator Johnson and Senator Fonseca and DeGraff. Hearing no objections, so ordered.
Motion.
Motion, Senator Bolkers.
Thank you, Mr. Chair. Mr. Chair, I move Bill number 36-0005, an act amending Title 16, Virgin Islands Code, Chapter 2, Section 99, establishing a mandatory bail amount in domestic violence cases, as amended, be favorably voted upon in this committee and reported out to the Committee on Rules and Judiciary for further action and consideration. I so move.
Second.
A motion has been made by Senator Bolkers, second by Senator Fonseca and DeGraff. Hearing no objections to the roll call. Roll call for bill number 36-005 as amended.
Senator Angel Bolkers Jr.
Yea.
Senator Bolkers, yea. Senator Dwayne M. DeGraff.
Yes.
Senator DeGraff, yea. Senator Ray Fonseca. Senator Fonseca, yea. Senator Kenneth L. Gittens. Senator Gittens, not voting. Senator Franklin D. Johnson. Yes. Senator Johnson, yes. Senator Gittens, absent. Senator Avery L. Lewis. Senator Lewis, yea. Senator Clifford A. Joseph.
Yay.
Senator Joseph, yea. Mr. Chair, you have 6 yeas, 1 absent.
Bill number 36005, an act amending Title 16 Virgin Islands Code, Chapter 2, Section 99, establishing a mandatory minimum bail amount in domestic violence cases, as amended, has been approved by the Committee on Homeland Security, Justice and Public Safety, and will be forwarded to the Rules Committee and Rules and Judiciary for the further consideration.
Point of personal privilege.
Recognized, Senator Bokers.
Thank you so much, Mr. Chair. And Mr. Chair, I wanted to thank you and the members of this committee for voting favorably on the measure before us. I want to assure you that once it moves into the Committee on Rules and Judiciary, there will be another tweaking of the bill to make sure and assure that we are all on the same note of music, so to speak, moving forward. So I really want to thank you all for your support of this measure, in addition to thanking the Attorney General's Office, the Virgin Islands Police Department, along with the Women's Coalition and the Family Resource Center for all of the work and support that they have given towards this measure today. Thank you so much, Mr. Chair.
Thank you, Senator Bokers. Colleagues, this has concluded the business of the committee. I would like to thank the central staff of the legislature, the testifiers that came before us today. I also want to thank my colleagues and my staff for providing a productive meeting. The Committee on Homeland Security, Justice and Public Safety meeting of April 3rd, 2025 is hereby adjourned.